Hello, everyone. I invite you to take your seats. So it's very nice to see everyone for the second day of the conference, during which we'll have a lot of discussions, a lot of interesting presentations. And without further ado, as you can see from the program, we have our second keynote lecture for this conference called Tendencies in EU Consumer Sales Law, from Classical Notions of Contract Law to Market-Centered Perspectives. And this keynote lecture will be delivered by Professor Dr. Felix Malch from Frankfurt am Main Goethe University. So please, Professor, the floor is yours.
Okay. Now. Yeah. Okay, great. So thank you very much for the kind introduction, dear participants of the conference. I hope you all enjoyed yesterday's social events, those of you who are attending on-site, and I would also like to extend special greetings to all who are following online. This is great that we have both of these options this year for the conference. And of course, the panels with your presentations should be at the core of the conference and not the keynote lectures like this. And I also fully understand, of course, that in times of war against the Ukraine and other severe crises like pandemics and climate change, climate crisis, probably private law issues are not at the heart of the discussion at the moment, but nonetheless I would thank the organizers of the conference to have the opportunity to present some thoughts about tendencies in EU consumer law, and I hope that it will be of some interest to you. And what I would like to present is a development which I have labeled, as has been said already, as a development from classical notions of contract law to a market-centered perspective. So I would like to make two main propositions in this presentation. The first one is that the general development of EU sales law is heavily influenced by what I would call a paradigm of online sales. Although we have, besides the new phenomenon, or maybe not more so new, but it's gaining momentum, of online sales, we still have, of course, traditional modes of contract law and of consumer contracts. But my claim would be, from a European perspective, EU perspective, the whole of consumer contract law is more and more influenced by paradigms of online sales and patterns of regulations of online sales. And so the question, of course, the follow-up question is, what is this legal paradigm of online sales or online markets? And I would propose that according to this development or to this perspective, the primary aim of contract law is no longer to protect individual autonomy and to level out parties' interests, which I would label as a classical view of contract law, and which could also be called as a party-centered perspective on contract law, as I have named it here. But in contrast to this, the primary aim under this new paradigm is more and more to protect and facilitate markets as such. So this would be this market-centered perspective. And of course, here we can find the link to the idea of transforming the traditional European single market into a digital market, which is one of the primary aims, especially of the European Commission, which has promulgated it a few years ago to go into towards this direction, but also of the EU as such, of course. And I would like to do, I would make some clarifications. You might ask, is this really a contradiction? Is it sensible to set up a contradiction between a party-centered and a market-centered perspective or approach to contract law? And of course, it's not a strict contradiction, as I would like to make clear in advance. Of course, even if we consider contract law to be a tool for the specific parties to the contract and for leveling out their interests and for pushing through their needs and aims, they always need a workable overall market structure to realize their contractual aims. So both of the perspectives will be intertwined. And so the structure of contract law is never and was never completely focused on the immediate party's interest, but also on the general impact of the rules on markets and market structures. And this has been widely analyzed. I have just put here on the presentation two names coming from Germany. So both scholars coming more from a traditional contract law perspective, like Werner Flume, who was one of the most eminent contract law scholars in the second half of the 20th century in Germany, pointed to this interconnection and this intertwinnings between contract rules and market structures, and also Fritz Rittner, who was coming from the side of competition law and market law. That's why I have chosen to name him here as well. He was also pointing and emphasizing this interconnection, and I'm sure that in your respective countries there have been comparable analyses. But I still would say we still have the matter of priority. So what is or could be or should be the leitmotif of contract law, to use one of these strange German words which even made it to the English language. So German language is on retreat like many other languages as well, but at least we managed to infiltrate a very few words into English language, and this leitmotif is one. So what is the guiding principle? That's basically the meaning or the question. And I would say if we approach contract law from a traditional party-centered perspective or approach, of course the focus would be on freedom of contract. So the parties should be free to contract for whatever contents they want to do so. We have default rules which step in if a certain point is not settled by the parties, but they, in the traditional approach, they primarily fulfill a service function for the parties, so that they don't have to be afraid if they do not settle any point that their contract will be no longer workable. The default rules will step in and thereby relieve pressure from the process of contracting. And we have mandatory law too in contract law, of course, even in a traditional approach, but it is limited, besides facilitating some public interests, to protecting weak parties to level out the bargaining power between the parties. And this, of course, is an aim of consumer protection law in a classical or narrow sense. And what would be now the market-centered approach? In this market-centered approach, I would say the focus is more and more on standardization of possible contractual contract, not only by the sides of the businesses in terms of using standard terms. Of course, they are doing that, having done this for decades or maybe for even a century by now, but even the legal rules on contract law. So contract law itself is more and more aimed to standardize possible contractual contents, and therefore we can find in this new paradigm mandatory law also in cases where we cannot really see a clear need of protection of a certain party. So mandatory law somehow becomes an end in itself to standardize what is going on in contractual relations and to make markets workable and more easier by the standardization. We can also witness, and I will come back to this a little later on, what I would call bonus rules for consumers to boost consumption. So these are rules which, if we analyze them, are not really meant or necessary, as my proposition would be, to give consumers equal standing with the businesses, but which benefit them overly in a way, and thereby giving incentives to consume more and more and to boost consumption. So a kind of carefree consumption environment created by contract law. And the third point, we have a focus in the new paradigm of contract law on equality of competition of businesses in cross-border transactions, and I will come back to this as well. So what I would like to do is to exemplify these phenomena or this development, this shift, very shortly across several fields. I would like to touch upon international jurisdiction and conflict of laws, substantive EU sales law, alternative means of dispute resolution, and a few words on private governance by contract and technology. Of course, you could say this is way too much for such a short lecture, and maybe you are also already afraid that I will take the whole day, but I can assure you I will not, because I have to go have my flight back on at 2 already, so there's some natural end of it, and I will only touch upon it briefly, but I think it's important just to say a few words on each of it to give a little more broader picture. We will not be able to go that much into detail, but some food for thought as a purpose of such a lecture like the Wise Ministry said yesterday. Okay, let's have a quick look at international jurisdiction conflict of laws. So for cross-border consumer online sales, the relevant legislative acts from the EU are as many of you know, are the Brussels 1 bis regulation for determining the competent court for international jurisdiction, and the Rome 1 regulation for conflict of laws, so what substantive contract law is applicable. And they have in Article 17 of the Brussels regulation and Article 6 of the Rome regulation about the same principle, which goes as follows. If we have a cross-border business-to-consumer sales contract, if a seller directs, that's the important term, its business to the market in which the consumer has its habitual residence, and if the contract falls within the scope of such directed activities, then first the consumer's place of habitual residence will be the place of jurisdiction. And the substantive contract law of this place, so consumer's residence domicile, will be applicable to the contract, and these cannot be changed, or it cannot be deviated from these rules to the detriment of the consumer by any contractual term, jurisdiction agreement, or choice of law. So if a consumer from Lithuania, for example, is buying something in an online store, online shop from a French company, and if later on any dispute is coming about on this contract, the consumer has the right that this dispute will be carried out in Lithuania, and also Lithuanian consumer law will apply. And the parties, and especially the French business, can in substance not change on anything on this. So these rules are clear and well settled, and of course, as you can see, they enforce the principle of market focus and standardization. So wherever you are coming from as a seller, with the market you are targeting, you have to abide, you have to play by the rules of this market. So you have this moment of standardization. What is interesting by now, which I would like to point to very briefly, that these rules were originally modeled for online sales only. So this was the specific intent of the European Commission or the European Council and the European Parliament. But the Court of Justice of the European Union has given them a much broader reading and applies these rules these rules to many situations of classical on-spot contracts as well. So just to briefly to modify our example a little bit, if you have this French company, online marketing also in Lithuania, but if now the Lithuanian customer is not buying the goods online, but is traveling for a holiday to Paris and buying the same goods in a shop in Paris. These rules, according to the judicature of the European Court of Justice, will apply as well, regardless of whether the online targeting marketing had any influence, regardless of whether the Lithuanian customer even know at all about these online activities. It will still have the right to have any dispute settled in Lithuania and to have applied Lithuanian consumer protection law. And this is discussed a lot, but I would take it as an evidence for my claim that the paradigms of online sales, which were modeled for this, tend to spill over in the European structure to traditional contractual situations as well. Okay, so far. Then let's go on to substantive EU sales law. Some core developments in this area. What types of online paradigms can we find in this field? Okay. What is important on the one hand is a shift from, and many of you know this as well, I'm sure, is a shift from the principle of minimum harmonization, which still was the basis of the 1999 Sale of Goods Directive, to the principle of full harmonization, which is the basis of the Consumer Rights Directive and the new Sale of Goods Directive from 2019, which got into force in the member states by the beginning, in most of the member states, by the beginning of this year. Under the principle of minimum harmonization, the EU sets a basis, a kind of floor for consumer protection that has to be abided by in any EU member state, but the member states are still free under this principle to be more favorable, so to guarantee an even higher standard of consumer protection. And this is different under the principle of full harmonization. In this picture, to stay within it, the EU directives are no longer a floor, but also a ceiling. At least in principle, there are some exceptions, but now the member states have to guarantee the European standards, but they can also not exceed it in favor of the consumers. And there was a lot of discussion in it whether this is sensible, and many commentators criticized this shift because they said, well, all the consumers need is this minimum protection, and then if a certain member state still wants to be more favorable, it's only for the good of the consumer, and it's not a problem at all. But what the European Commission is pointing to, and from its perspective rightly so, I think so, is the need for equality of competition for all European businesses in European-wide online markets. According to this new principle, the businesses should be sure wherever they market their goods in the European Union, always about the same rules will apply. And they do not have to expect even higher consumer law standards. And this should make it easier for them and should boost cross-border offerings in Europe to facilitate the market again. So this is one important development, and the other one, which I would call the phenomenon of bonus rules for consumers to generate trust and to boost consumption. So these are rules, maybe in a little provocative way or analysis, which not only me, but many commentators would say they are not really necessary to fulfill legitimate interests of consumers, but they are in a way overly consumer protective to create a kind of carefree consumption environment and to boost consumption. I have just brought to you two examples which are discussed in this context. The first one is something which you may well know from your private consumptive practice. It's the mandatory 14-day rights of withdrawal for consumers in online distance sales. So whenever you are making an online sale, you have at least this mandatory 14-day rights of withdrawal. But many commentators would say this is not really necessary to give consumers a fair position in this contractual situation. It would be enough, for example, to let consumers choose whether they would like to have a contract with a withdrawal right, or maybe to waive it and to get a better price, because of course such withdrawals are costful, as we know by now, and they are sometimes also a problem from an environmental perspective, if everything is ordered and then sent back and it has to be refurbished and so on. Some other commentators said, it's enough for the consumer, it's fair for them if they could choose. The European legislator is somehow going over the top with this mandatory right, and by saying you don't have to take care, buy, consume, and you will always have the right to send it back. So there's discussion about it, and the other more recent thing would be the mandatory one-year shift of the burden of proof as to quality defects in favor of consumers, according to the new Sales of Goods Directive. We had this on a lower level 6 months before already under the old Consumer Sales Directive, but now it's 1 year, so whenever within 1 year after handing over of the goods, some problem turns up with them, it is presumed that it was an initial defect which triggers consumer rights. And in many cases, it will be difficult for the businesses to prove otherwise, even if there might have been some misuse or accidental course with respect to the goods. So at least not from a doctrinal, but from a practical level, this might be tantamount to a 1-year warranty for durability. And of course, you may welcome it as improving or facilitating sustainability. So you could say, if you have this rule, the businesses or the producers have an incentive to produce more sustainable goods, and that might be welcomed from our future perspective of consumptive markets. But coming from a traditional contractual perspective, one would say, well, there should be room for differentiation for goods at different price levels, and maybe goods at higher price levels. They should come with a warranty on a contractual basis, and there should be goods at lower price levels which should not come with such a quite an extensive kind of warranty. What we can see is that EU consumer law may drift away more and more from the idea of mere consumer protection and become more and more a means of facilitating on boosting consumption, not only but especially in online markets. Okay, a quick look at the alternative means of dispute resolution. These are also important. For quite a long time, the European Union was focusing on the substantive consumer law, but more and more they encountered that it is equally important to have a good enforcement of consumer rights, and so the availability of efficient, low threshold and fast means of enforcement by now ranks very high in the EU consumer law agenda, and we have several legislative acts in that respect. One or two acts from 2013, the Directive on Consumer ADR, which requires the member states to have high-quality entities. What that means is a little more specified in the directive. I don't want to go into details of it. And we have the supplementive regulation on online dispute resolution for consumer contract complaints. This maybe sounds a little greater than it actually is. So it's not a full-fledged mechanism of online dispute resolution for consumer cases, but it's merely a platform setting up by the European Union, informing consumers about possible ADR providers which might be willing to offer an alternative way of solving disputes for the specific case at hand. And the second, more recent important development is the directive on representative actions, also taking up previous and less developed European legislative acts, and now giving suitable bodies like consumer protection associations very wide rights to enforce consumer rights on behalf of them at a collective stage. And so, of course, all of this might make enforcement more efficient, and that's the aim. So far, so good. But as we have to see, these mechanisms are no longer or not primarily aimed at enforcing consumer rights in a legal fashion and in a way which would accord with classical contractual thinking. Rather, the focus is on quick, cheap, and standardized solutions, which in many cases might considerably deviate from what would be the contractual position and the contractual rights in a strict sense. So, for example, commentators, and I think this is quite apt, have been talking about that in case of consumer ADR, we have a type of rough justice. It's no longer to really get what the consumer rights are, but just to get a solution which is acceptable and in the best case fair and equitable to the consumer. But it doesn't need to have any necessary resemblance to what are the substantive contractual rights in the case of hand. And with respect to this representative actions, you might say, well, this is a kind of semi-public market surveillance. So also these bodies are not public bodies, public authorities in a strict sense, but at least, or still, they are looking at it from a collective perspective. So it's no longer individual enforcement of rights in a classical civil procedure style, but it's a kind of more collective market surveillance in the form of representative actions. And so here we can see as well, and coming back to my main claim, the tendency to a market protection and facilitation rather than to rights enforcement stricto sensu as we would know it from classical contractual thinking. And so some final words. Of course, I'm running out of time, but please allow me some final words on private governance by contract and technology, which of course is also very important in more recent days and in the foreseeable future. And at the core of it, of course, we have the rising power of online platforms, intermediary online platforms, which more and more act as market guards. So many of the transactions are carried out via this online platforms. And so whether you have access to them and what is going on them is playing a core role for consumptive behavior of many of us nowadays, and you can also think of your own behavior, whether you are using these online platforms. I'm sure that many of you will do in a lot of different ways. And so what is typical for these online platforms and the contracts carried out via them is that we more and more have a thinking in terms of overall customer relations between these platforms and the consumers, instead of isolated or separated contracts, sales contracts, or whatever it may be. And this, of course, came about especially with the rise of multi-purpose platforms like, I don't want to make here advertisement, but I've used it because it's so telling. So the Amazon Prime platform. So Amazon started as a bookseller initially, then as a seller for goods, whatever. Then we had the marketplace, so third-party businesses could make offerings. And by now we have much more. We have the streaming services and so on. You may use it or comparable services. So they want to cover the whole life of consumers. That's basically, and to be a little provocative, basically their aim. And of course, this is so because they subtract or extract considerable economic value from data acquisition in the course of the contracts that are made on it. So one could say the important thing for these platforms is no longer an economic interest into the specific contracts that are made on the platform, but on the overall customer relationship and on binding the customers to the platform. And hence we can also see a declining relevance, at least in practice, of the rights and obligations in specific contracts. So, for example, maybe paradoxically, if you look at it, these platforms are quite often even more favorable if some problem in a specific contract comes about than even the quite protective European law would be with respect to withdrawal rights and so on. Quite often they are more favorable because they want to bind the consumer. So they do not extract that much of their surplus from a specific contract, but from the overall customer relation. And okay, so that's a phenomenon, and hand in hand with it, we have more and more private rulemaking by this intermediary online platforms for the platform transactions carry out on the platforms. So there are terms of use, payment system, feedback system, specific dispute resolution systems. And I would like, as a kind of final point, point to an interesting discussion which is going on recently with respect to this. So there is a dispute whether these rules set up by the platforms are classicals, have to be viewed from a legal point of view as classical standard terms. And then, of course, they would be subject to a review under the Unfair Terms Directive by the European Union. Or, this is the opposing view, some scholars, especially from competition law, say, no, these are not standard terms, not contractual terms, but this is market organization. So we should not view on it from the point of view of contract law, but only from competition law. So we have to see whether this platform has a dominant position in the market, and then we have to balance this by the means of competition law. But it doesn't have, we shouldn't touch upon their terms, and we should not scrutinize them by the traditional contractual means like unfair terms review and so on. And here you can see against this battle between a classical contractual view and a market, the view from the market and market structure. So quick summary, I think I have tried to present a paradigm shift in European consumer contract law, the protection and facilitation of online markets. It's gaining momentum instead of leveling parties' interests or merely protecting weaker parties. We have a trend towards standardization, full harmonization, and also an extended geographical scope of application, as I have shown the Brussels and the Rome regulation. And we also can encounter this decreasing relevance of separate contracts in favor of digitally managed consumer relations. So thank you very much for your consideration, and I'm very much looking forward to your next panels. Thanks.
Thank you very much, Professor. Definitely some food for thoughts, especially whether do we like the paradigm shift, one of the questions that I raised myself. So thank you very much for insightful presentation. And now we begin our third session, questions about law and pandemic, and I invite participants to join us up front.
Hello, we can start. Good morning to everyone. It's a great pleasure to be back here again, inside. We have this third session today. The main topic is questions about law and pandemics. And I don't think I need to comment or justify why we have this panel today. We have 4 speakers. 3 of them are here with us in this room. The other one, Raquel, should be online. Maybe you can confirm me? She's online? Yep. Okay. Welcome. Without no further comment, I give the word to our first speaker, Ahmed Abdallah Faiz Azam from Vilnius University. And your topic is legal systems and international commercial arbitration in the time of coronavirus. You have the floor.
So maybe you can go there. I like to be basic. That's working? Yeah, perfect. Nice to meet you. Hi, everyone. My name is Ahmed Azam. I'm from Jordan, but originally I born and raised in Bahrain and Dubai. My mom from Sweden. It's mixed. And I'm studying here. Imagine that. So I chose this topic actually because it's important subject. And then the same time, and this time before 2 years ago, normal life becoming not normal life. If you want to travel to another country, you should have corona test. You should like follow the rules. So imagine in this part of the world, when everything is different, everything system is different. So it was hard time in Gulf region. So yeah, that's perfect. So let's start about international arbitration law and commercial law during the pandemic, COVID-19. Since this time, Gulf region, they have arbitration law. They was using DR, but it was not in reality succeed. It's mean, if you have a problem, people from international or abroad, they don't trust the system there because they follow another rules. They mix it between international rules and Islamic law rules. Gulf region have almost more than 60 or 50% from receive all the oil in the world. Oil, gas companies, international companies, people living abroad, they coming to stay in Bahrain, Dubai, Emirates. So those people, if they have a problem, they trust the international system, not the normal system. Because the normal system, they apply for Islamic law and other of laws. So during the pandemic, those laws stopped because the government, they was shocked. They didn't know what should they do. They didn't know what they should behave. In the same time, Mohammed bin Rashid, the leader of the Dubai, they tried to have some solution. And they have a conference. And they was talking about this conference name, Be Strong. Be strong and be safe. And they was focusing about arbitration law, ADR. He was deciding that they should do online, they should use the technology to use those ADR in front of everyone. It's me, for example, we're going to talk about some cases. It happened in Gulf region in this time. Between some companies, the owner of this company is Indian, but he have like US passport. In the same time, some Arabic from Bahrain, he have their own companies in Dubai, and he have two passports, Swedish one and Bahrainian one. So in this time, arbitration they was stopped because pandemic. There is no international people they can enter the countries. In the same time, this country is not a stability at all. So they was using not arbitration law, a normal law during this legal system problems. So in this time, they was calling some arbitrator, he living in US. And it was the first time it will be online arbitration, ADR, in Dubai, as without any confirm from the legal system. It was almost 3 days, this case, they cannot get any solution from this case because of the pandemic and coronavirus. So after that, the legal system, they proved in some positions, you have flexibility to do ADR online. And after that, about this case, they win the US guy, this case, in online. Second things, let's talk about, I'm talking actually basic, I like to be basic. I'm someone actually, I like to be basic to understand my point. Because actually in these areas, they're using a different law, they're using a different system. It's not easy to be as a European to understand these things. So for example, since I came here and I was coming from this country to Lithuania, so now change the subject a little bit. Be fresh. Today it's weekend, Friday, so we should be fresh. So when I came to Lithuania and Corona start, people ask me about the system and ADR and the arbitration law. Okay, what they're gonna do there as a European, as a international? They have a specific law. For example, family cases. If family cases during the pandemic and COVID-19, they cannot fix it. For example, I married some women from Lithuania. I want to divorce with her. In the same time, the legal system, it doesn't work because of the COVID. So she needs some papers from Lithuania, for example. In this time, they have a lot of changed some of the law. For example, if you are foreigners and you want to divorce and you want to make more easier this practice, you can go to the court, to Islamic court, but in the same time, in this time it was working as a normal court, because in Dubai they have two, or like in Gulf region, they have two kind of the court, Islamic court and civil court. If you are a Muslim or like you believe in Islam, you will go to this Islamic court and you divorce there. But when you both, like one from abroad and another one, they're living in the country, they're using a civil court. Civil court in this time, it was not working because civil court, the judge of that is not Emirates, he's from abroad. And since COVID start, they didn't have any solution for these things. So after that, you can use this system with Emirates judge. It's mean. I am from Jordan. I'm working with civil court. Before, it was not easy to decide to divorce or do ADR or anything without any permission from the government. But since COVID start, they give permission for everyone. In the same time, the high court, they can make these principles. In my opinion, COVID time or the pandemic, it was a good time for Gulf region. Why? It's nice sometimes to have some action in your life. Sometimes when you change, when you be like instability, and then suddenly you don't have anything, it's good sometimes. Why? Because like in Gulf region, they not use arbitration law. They was just put it as an international. They're trying to use it. Normal people don't trust arbitration law there. If you have any problem, they go to normal procedure. After Corona right now, they're using arbitration law a lot. So, for example, like in Dubai, they increased more than 25% of ADR after pandemic. Third things, what I believe, okay, of course they have advantage and disadvantage for COVID in this region. The advantage it was that, the disadvantage it was legal system, not stability, long list. If you want to do case, you need to wait almost 4 or 5 months if you like urgent case. But after the leader Mohammed bin Rashid, they do this conference and they're talking about ADR, and we should use ADR, especially right now, Dubai, they're trying to be the leader of this area. So after just small wars, a lot of things have changed. So right now, if you have some problems and you are from European countries or not like original from those countries, you can finish almost your case in 1 week. They do 3 stages of systems of legal. They have VIP legal system, a normal legal system, and basic legal system. It depends about your case. If you, as an owner, in the commercial international companies, and they have a lot of workers, you can in a VIP system. It's mean, you can choose your language. You can choose actually the time, which time did you want to start your case. All these advantages start after Corona. What I believe in the same time, after Corona, we learned a lot. Example, me, for example, I cannot know how to cook. Right now, I know how to cook. After COVID, I was done to play sport. I start to play sport. So it's nice to have a normal life. In the same time, it's nice to learn from any hard things in your life. And this is what I believe in Gulf region, it's happened. After COVID-19, there was changing a lot. All legal system, they understand what it does mean arbitration. What's this important to make every legal system more easier, not more complicated. So those things, it was like, in my opinion, really good things. And the bad things, until now, it's not happening. I hope if they will increase the schools of arbitration law. After pandemic, there was doing 2 schools more. If you are studying in Faculty of Law in any countries, you can apply to be ADR in Dubai or Qatar. But they not do this one like these things in reality sometime. It's mean, if you know someone inside, you will get it. If not, you will not get it. Since Corona start, these things it's coming not increasing. This increasing a lot. But after how to say, when Arabic when say good things, it will be better things. After those time and the legal change, they have schools, they can use, they can discuss about it. So all these things, it was a good things in Gulf region. I will not take more than this time because actually I'm always believing small words. It will be better than long words. If you have any questions, I'm happy to listen. You have any questions? For another one? Yeah,
we have all the panelists and
yeah, for me, I'm done. Finish. Everyone know Corona. Everyone have Corona before, so I hope right now everything's feel free and have a good life and happy Friday. Thank you so much.
Thank you very much. Yes, we have to listen all the presentation, and then we have a global debate, so we can go back to your presentation later. So now it's the turn of Goda Strikaite Latushinskaya. I hope I do not pronounce too badly your name. Online courts, status quo or quo vadis?
Okay, I think I can start. Good morning, everyone. It is so good to be here in person, to be able, to present my ideas in person, to be able to discuss different points of law view during coffee breaks, during lunch breaks, to meet all the participants in person, and to network, like in general. So my name is Goda Strikaite Latushinskaya. I am affiliated with Vilnius University Faculty of Law as a PhD student, as well as a research and teaching assistant. And the aim of my today's presentation will indeed be to present or to discuss the status quo of online courts and to evaluate to what extent are we eager to change or to transform traditional courts and traditional ways of delivering justice. So looking at the road now, we are somewhere here. I would say that this is the status quo, or this is the current situation. And in contrast to the overall picture of digitalization of administrative case handling, of courtrooms and court administrations were for many years remarkably untouched by the general trends of digitalization. It is mainly within the last decade or so, I would say, that courts have opened for a more through digitalization of court systems. But anyway, a lot of countries in Europe have digitalized practically all parts of written procedure of the courts. There are systems that allow parties to upload files, to submit procedural documents, also to follow the case. And we have these systems for a while now. For example, the first system that all Estonian courts used was called COLA, and it came into force back in 2001. And in 2006, the court information system in Latvia was set up. And in 2004, Lithuanian case handling portal Liteko came into force. So the first takeaway would be that, the first takeaway would be that a lot of countries already have digitalized practically all parts of written procedure at courts, and that we had these systems for a while. Now, talking about nowadays, an important aspect, and considering that I was put in this specific panel about the pandemic, an important aspect to discuss is the COVID-19, which has greatly impacted the justice system all over the world. And while it is still too early to conclude on the impact of the pandemic in the everyday life, the overall picture appears to be that the COVID-19 led to an increased use of communication by digital means. And to the extent that online proceedings were used, parties communicated using different electronic platforms. Participants in court proceedings were allowed to use commercial options such as Skype or Zoom, since the existing internal platforms for communication didn't have the necessary capacity. However, in the long run, I would say that the pandemic should not be considered like a game changer for the already very digitalized states, such as, for example, the ones I already mentioned, like Estonia, Latvia, Lithuania. But anyway, there are considerations to institutionalize hybrid format of meetings. So we can conclude that after the pandemic, it is likely that most countries will keep the remote court hearings, and that it will become traditional in the daily work of courts. But that is it. What is important to understand is that my third takeaway from the current situation or from the status quo is that I think they are still tiny steps, and this is not a change in a paradigm. This is not a change in the model of understanding how justice is administered. Now let's look at the near future. In my opinion, it should be somewhere here. Talking about near future, I will discuss to you two different aspects, and the first one is virtual reality. So, whereas augmented reality changes users' perception of the world around them, virtual reality largely or entirely replaces that everyday environment with a wholly simulated one. And the virtual here is not the same as when we're referring to virtual hearings, which essentially are just video-enabled hearings. But what I have in mind is instead is the court hearing, which is a synchronous one, like the ones we have today, that is actually conducted in a virtual reality. And all participants would enter this alternative or online environment, online world, and proceedings would be conducted there. It is actually possible that public hearings could take place in a virtual reality environment. I believe so, and I can imagine cases being handled in lifelike situations, lifelike simulated courtrooms. Also, I think it could be good for trainings and so on. Another important or interesting aspect when we talk about virtual reality that is actually being widely discussed among the professors of symbiosis of law and future, about legal futurists, so-called, is avatars. So in virtual reality, court parties could appear not as themselves, but as avatars, masking their real identities and characteristics or leaving them undefined. And the idea of being represented in a virtual reality by some kind of avatar may seem bizarre on a first encounter, but it is actually being widely discussed among legal futurists, as I mentioned, but because they deem it to be like a good way to ensure that the principle that justice is blind and that justice should be blind. Now turning to the asynchronous online judging. So this is another interesting aspect. This is actually something that is already being implemented in England and Wales. I think that this will be another interesting shift that we will probably experience in the near future. So traditional court work, as we know it, is synchronous, which means that all participants must gather at the same appointed hour at the proceedings, and they unfold in real time. So this is some kind of a like live performance. But in contrast, when we talk about online court activity that is asynchronous, it means that there is no need for everyone to be available at the same time. It's like using, for example, email. Participants can take their contributions whenever suits them and whenever they can. So there is a so-called online judging, which is a process where evidence and arguments are presented to judges through some kind of online platform, and the judges then deliver their decisions, their judgments, not in an open court or in any kind of virtual reality, but in a special platform. So basically, I don't know, I think it's pretty simple to understand, but the court proceedings are conducted like an ongoing exchange of emails, exchange of attachments, and then cases are progressed and disposed of in a certain period of time. There is one example. There is a service called Matterhorn, which is an online dispute resolution platform that piloted in 2014. And it is available on smartphones. It is available 24/7. And it allows litigants to communicate asynchronously with judges, with court officials, and so on. And parties are notified of court decisions via this specific platform. So this was just an example to show that it already works. And actually, this platform is quite a successful one, I would say. So we'll see if we will have this asynchronous online judging in the near future. Now, turning back to the road again, because this is the metaphor I chose for today, I want to talk about not so near future. So, and I can see I'm running a little bit out of time, so I'll try to be short. Okay, so these are two examples, and actually they are intertwined and they're similar. So in 2019, Estonia announced that a robo-judge project is currently being developed to resolve small, meaning up to 7,000 euros, civil disputes arising from contracts. And it is believed that court systems in such a way will be able to concentrate more on complex cases, and cases will be resolved more efficiently, and that it will reduce the current backlog of judges. There is also the Hmcd Escort reform program, so this is something that is happening in England and Wales. And it is actually reshaping the whole court work as we know it today. And basically the aim of this program is to establish an internet-based court system with a three-level system. And what is interesting is that the idea of artificial intelligence making final decisions is not ruled out and is deemed to be a reality in the future, at least according to Richard Susskind, who is like a frontman of this program, and who is he's a legal futurist, and he is working on this project for like 5 years now. So at this point, I will just summarize that we are talking about a change in the concept of how justice is delivered, a change in the paradigm and the use of artificial intelligence to make decisions. So I just wanted to emphasize on that not in the near future we have some bigger changes coming our way. But I think when we talk about, especially when we talk about upcoming changes in courts in terms of European Union, in terms of member states, we always have to keep in mind the European approach, and we always have to balance between what European institutions, what is their aspiration, and what is the aspiration of the users of court, what is the aspiration of developers of various technology, and so on. So now talking about getting back to the European approach, on October 2020, European Parliament adopted a resolution on a framework of ethical aspects of artificial intelligence, robotics, and related technologies, which states that technologies that can be used to make automated decisions and thus change the decision taken by public authorities should be treated with great caution, especially in the areas of justice. It is also noted that member states should use such technologies only if there is a detailed evidence of their reliability and if meaningful human review is possible. So to sum up, the European Parliament encourages careful use of technology and gives priority to fundamental human rights and freedoms. Now a few more ideas will follow on the screen. The first one is that this idea, mainly the idea that a proper human revision should be ensured, is supported by European Council, which in its conclusions of 2020 stated that the use of artificial intelligence tools must not interfere with the decision-making power of judges or judicial independence. A court decision must always be made by a human being and cannot be delegated to an artificial intelligence tool. This was what was said, and another similar view, or this kind of view was supported by the European Commission, that in its communication of 2020 stated that the final decision-making must remain a human-driven activity and decision, and at the same time it is important that judgments are delivered by judges who fully understand the artificial intelligence applications and all information taken into account therein that they might use in their work so that they can explain their decisions. So to conclude the European approach, so even though all of these documents I just mentioned are sources of soft law, so which means that they are not mandatory, we can already sense, we can already see and feel what is the European approach, what will be the European view, and what already is the European view. And it is that the use of technology to make final decisions, at least at this stage of technological development, and I want to emphasize that, is not encouraged. And this is the European approach to bear in mind when talking about the future of online courts. Instead of the conclusion, to finalize, I want to share some closing remarks. So to sum up everything that I've just said, I just wanted to say that digitalization in general is promoted in order to make case handling easier and more efficient, in order to reduce the backlog, in order to reduce administrative burden, and so on. Another important aspect I discussed today is that the COVID pandemic has led to an increased use of oral meetings and using Teams or Zoom platforms and other various similar communication channels. But looking into more advanced technologies, artificial intelligence may be seen only as part of anonymization or as part of search, like some kind of search algorithms are being used in courts, but that is it. No more advanced technology is currently, at least now, being used in courts. I'm talking mostly about the European states, about the member states. So basically, one takeaway would be that as of now, we are very far from a revolution, and this is not some kind of a paradigmatic change. We changed some tools, yes. We moved to more convenient ways to reach the same result. We adapted to a changing world, but we are still on the road of change, and bigger changes, in my opinion, can be seen on the horizon. Now to finalize, I want to spend a minute or so to consider, like all of us together, we can think that in a world where most of our lives happen online, where all goods or services are within the reach of a phone, isn't our understanding of the administration of justice becoming archaic? And the question remains, to what extent will our current understanding of the administration of justice change, and to what extent do we want it to change? And because now is the time when everyone understands the potential of technology that is evolving way faster than the regulation, I think we as lawyers should have our say, and we should decide, before someone decides for us, how we understand the future of courts and the future of justice. As I mentioned, we are on the road, and with my presentation, as our first keynote speaker, Gabia, yesterday said, I aim with this presentation to inspire you, lawyers, to ask these questions and to make the change before someone else makes it for us. So that was all I wanted to say today, and thank you very much. I'm looking forward for the discussion. Thank you.
Thank you very much. We are not now joining our online speaker, Raquel Ebereta from University of Antwerp. Hello,
Yes.
can you hear us?
Yes, I can hear you. Can you hear me?
Maybe a little bit louder, if it's possible.
Is it good now?
That's perfect.
Okay,
So
awesome.
your title will be The Use of Technology in Dispute Resolution, a framework for the study of ODR, online dispute resolution. The floor is yours.
Yes, so let me just share my screen. All right. Can you see my
It's okay
screen?
for us.
Perfect. Okay, let me just make it full screen and see if it... Right. Okay. So first of all, I do regret not being there, but I'm also thankful that technology made this possible and we can still share our research even though we're not physically present. All right, so I'm doing my PhD at the University of Antwerp in Belgium, and I'm dealing with procedural justice issues in online dispute resolution. But today I want to talk a bit more about the definition of dispute resolution and the impact that the pandemic had on the field of online dispute resolution. So given the little time at my disposal, I'll get started immediately. And I want to make this a bit interactive, so please have your cell phones at hand. And hopefully this will work, because it would be quite awkward to have technology related issues while speaking about online dispute resolution. Anyways, so, okay, first of all, I'll give you an overview of the impact of the pandemic on dispute resolution. So several jurisdictions have been surveyed over the past couple of years, and some global trends have been identified. So those 6 trends are ever present and have affected pretty much all jurisdictions in the world. To begin with, an increased volume of cases and also an increased complexity of the disputes. Notably, the pandemic is a novel and unprecedented situation, and it also brought up novel issues that had never been addressed by courts and tribunals and generally dispute resolution systems before. So the fact that that in-person gatherings weren't possible anymore, and this increased volume of cases caused significant court delays and disruption. Depending on the legal system, there are some jurisdictions were more advanced and were already implementing some remote dispute resolution programs. So for those jurisdictions, it was quite easy to adapt to the new normal, as it's being called, and actually get back on track. While some other jurisdictions were didn't have those options, and so they had to develop quickly. They had to develop systems that could address the situation and make online dispute resolution possible, say remote dispute resolution possible. This was also accompanied by the development of practice notes, guidelines, and protocols to address this novel scenario and just provide some guidelines and guidance to professionals and parties that were dealing with dispute resolution remotely. So, of course, there was an increased adoption of information and communication technology, which also developed rapidly to adapt and support dispute resolution in this novel situation. But among all this, there's been a lot of talking about online dispute resolution. Actually, do we really know what it is? Because by reading news and articles, it seemed to me that online dispute resolution came to encompass pretty much anything that takes place online. So today, I also want to hear from you and what you think about this issue. Well, actually, if you scroll literature and articles and websites, you may find a lot of different definitions of online dispute resolution. And some institutions at an international or regional level also try to provide their own definitions of online dispute resolution. And I put 3 definitions here, so it may take a little time to read them. The first one is from the United States, so the American Bar Association. While the second one is from the UNCITRAL Working Group number 3, and the last one, very familiar to us, from the Regulation 524 of the European Union. So while definitions vary, the common core of all definitions comes down to the use of technology and dispute resolution. So this is the minimum common denominator that we can find, but it doesn't actually say much. So I feel like we need to be a little more specific in terms of what online dispute resolution really is, because as of now, there is currently no universally accepted definition, and we're just left with that minimum common denominator, while there are so many processes around that take place remotely nowadays. And I believe we do need to draw lines somewhere and start to put things in boxes to just have more clarity in the field. So you're all legal professionals or academics, and I have designed a quick online poll for you just to see where you would draw the line and what you think online dispute resolution could be. So to do this, if you're connected remotely, you can just scan the QR code, which I imagine is a bit difficult if you're there in person. So you can type in slido.com and you should just get a pop-up asking you to type in this code. So if you can do that, we can just see the results together. You can select multiple options. You should be able to get the question right away. So I'll just give you a couple of minutes to complete the online poll. Just move it to a minute. Okay. I see answers are coming. There's no right or wrong answer, so don't. Right. Okay. Nice. Okay. Well, I see that the bars have stopped moving. So, yeah, this actually reflects pretty well the different orientations that are around. So yeah, you can continue voting in the meantime, but it's very interesting also to see this. Well, depending on the definition you adopt and where you draw the lines, anything can be online dispute resolution, as we can see. So yeah, we do have like 73% as to mediation conducted through online platform and blockchain arbitration. So there are different phenomena around. And if you justify your definition, actually anything can be online dispute resolution. But let's now move on to the next slide. Okay, all right, there we go. So in my research, I was myself struggling with the definition of online dispute resolution, because the definitions that are around are quite broad, but it's understandable that they need to be broad, because ODR, online dispute resolution, and anything that happens online is a rapidly evolving phenomenon. And there's also a need to accommodate for new information and communication technology tools and methods that may come up in the meantime. So the notion needs to be fluid, but also broad enough to make room for these new emerging trends. I drew inspiration mostly from the UNCTAD technical notes on online dispute resolution, which tend to be more specific compared to other tools that have been published by international institutions. So by online dispute resolution processes for a historical argument, I would tend to say that it doesn't matter whether the process takes place partially or entirely online, but courts are not included in online dispute resolution, because to me, and also I'm not the only one saying this, online dispute resolution is a sort of offspring of alternative dispute resolution, and it was born as a response to the unsuitability of courts to address certain matters. So to me, it makes more sense to just exclude courts and tribunals from this phenomenon, even though they might use online tools. Where to draw the line? So to me, there needs to be something more specific, like a dedicated software conceived for their specific function of aiding dispute resolution. So to give an example of this, a mediator conducting a mediation via Zoom without more wouldn't fall under the definition of online dispute resolution. In that case, Zoom is a commercial software that anyone can use. It doesn't take any special skills, and it just provides a venue for the dispute resolution process to take place. It doesn't play an active role in the process, and the process would take place exactly the same in person. So it doesn't add anything more to the procedure itself. While a dedicated software plays an active role in the dispute resolution process and actually makes a difference. So the process would take place in a totally different way if the fourth party wasn't present. The fourth party is a definition for the online platforms that was created by Ethan Cash and Janet Rifkin in the early 2000s. And it's quite significant because it's something that adds to the two parties in dispute and to any third party that might be present in the process. So this definition of fourth party also allows us to identify the fifth party, which is the online dispute resolution provider, either the entity or the institution that supplies or administers the technology. So these core elements, I believe they add something more specific to the definition of just dispute resolution taking place online. And I was trying to change the slide, but it's not working. Okay, so anyways, why does this label matter? Why does it matter to be so specific about the definition and draw a line somewhere and put everything in a box? I believe that going forward, there will be a need for regulation of the field, and some attempts have already been made. So even though anything that happens online tends to be unregulated just for the nature of it, now going forward, and with these processes being more and more used, there will be a higher need of regulation. So understanding what we're talking about will also help us identify the appropriate procedural and regulatory framework, and actually help us understand what we're trying to regulate and what falls under that framework. It's also important because if we know exactly what we're talking about, we are better off identify the most appropriate dispute resolution method. So if some of you recall, ADR is a short for alternative dispute resolution, but it's also been referred to as appropriate dispute resolution. So this would be the case also for online dispute resolution, let alone all the applicable protocols and standards and guidelines that will be created and have been created already. So we need to understand how to apply those protocols and standards and what actually falls under the scope of those documents. One last thought, and I think it's also very important, we need to define online dispute resolution because there are some significant implications in terms of what training requirements are needed for neutrals. So using Zoom, anyone can use it, and except some small adjustments like making sure there's no one around the parties in the room. So there's really no need of any specific training, but when tools get more sophisticated and they actually play a significant and fundamental role in the dispute resolution procedure, there needs to be appropriate training. So neutrals need to be prepared, but also parties, they need to be aware of how to use those tools and how to make the most out of them. So this is very important, and I believe it's crucial to understand that before talking about online dispute resolution without even knowing what we're actually talking about. So I will leave you.
Raquel, excuse me to interrupt you, but you're running quite out of time. You have 2 minutes more. Is
Yeah,
it possible?
indeed. But this was my closing remark.
Okay.
So I just wanted to leave you with this proposed framework for the study of online processes. So alternative dispute resolution procedures are usually placed on a continuum, so a linear graphical representation. But given the complexity of online dispute resolution, I do believe there needs to be a grid factoring in all elements of the process. And by looking at all those boxes, we can more easily understand what type of processes we're using and whether or not it's going to be suitable for the parties or for the case at hand, considering the type of technology, the degree of involvement of the fourth party, and also the role of the third party in the process. So with this, I close my presentation and I thank you all for your attention.
Thank you very much. We can go back to your presentation later in the general discussion. And now our last speaker, Ugne Markevičiūtė from Vilnius University, transfer of prisoner in the EU during the COVID-19 pandemic with the Lithuanian example. The floor is yours.
Okay, so good morning, everyone, and thank you, Professor Miller, for an introduction. I'm Ugne Markevičiūtė, a PhD student and a researcher at Vilnius University Faculty of Law. And it's a huge honor for me to have an opportunity to address such a distinguished audience today and to share my insights on the topic transfer of prisoners in the EU during the COVID-19 pandemic, Lithuanian example. There is no doubt that the coronavirus crisis has put a massive pressure on everyone's daily life, including foreign prisoners convicted in the member states of the EU rather than their own. Starting from February, March 2020, most countries of the EU introduced lockdowns and states of emergency gradually came into force. In addition, several containment measures to protect prisoners' health, consisting primarily of suspension of all visits and regular activities to limit contact among prisoners and between prisoners and the outside world were taken. In 2020, the first and the only case addressing the spread of the coronavirus and the coronavirus restrictions as the ground of non-transfer reached Lithuanian courts. As a result, this presentation will focus on a brief introduction of the legal basis of cooperation between the EU member states in the context of transfer of prisoners, challenges in the light of the COVID-19 pandemic, and an analysis of previously mentioned Lithuanian case law example. To begin with, I want you to keep an eye on the illustration on the slide and imagine a situation where a person is a national of member state B. Still, he is convicted of a criminal offense in a member state A, where he has no family, social, or other links, and is sentenced, for instance, for 4 years imprisonment. Most likely, the enforcement of the sentence in the member state of conviction may not be optimal given the person's social rehabilitation, especially if the person does not understand the language of that member state. So this is the framework decision of the EU on the application of the principle of mutual recognition to judgments in criminal matters imposing custodial sentences comes to help. It establishes in what situations and how the EU member states cooperate concerning the recognition of judgments and enforcement of sentences imposed by another member state. Based on framework decision, the authorities of member state A, as in a given example, may return the sentenced person back home to a member state B to continue a sentence. As stated in the Councils of Europe Handbook on the Transfer of Prisoners, the opportunity for social contact with relatives and friends helps ensure that the sentenced person is prepared to be returned to the community. This objective may not be served if such a person is kept in a foreign state, when it is likely that he or she will no longer be permitted to live in that state after having served a sentence. Turning our attention now to the core features of the framework decisions which were challenged during the COVID-19 pandemic. First of all, mutual recognition and mutual trust. So this is the starting point of judicial cooperation in the context of transfer of prisoners, meaning that all EU member states respect fundamental human rights and trust each other's judicial decisions. Enhancement of social rehabilitation. The key aim of framework decision is to support the social rehabilitation of offenders who find themselves in prison outside their own country. Limited number of grounds of non-recognition and non-enforcement of the foreign judgment imposing a custodial sentence. There is a general duty to recognize and execute a foreign judgment that has been forwarded. As a result, the list of grounds for refusal are directly enshrined in the framework decision and is very limited. Clear time frame for the procedure. The final decision of the recognition of judgment should be taken within 90 days. After that, the physical transfer should be completed within 30 days. Consequently, the framework decision on the transfer of prisoners ensures more efficient and uncomplicated legal cooperation among the member states of the EU with regard to transferring the sentenced person for further execution of the sentence. However, as you all can see from the slide, due to objective reasons, such as certificates issued only in urgent cases, decreased abilities to carry out different procedural measures, travel restrictions, closed borders, physical transfers of prisoners under framework decision were postponed by the majority of the EU member states during the COVID-19 outbreak. As emphasized by the Council of Europe, during the COVID-19 pandemic, judges and prosecutors worked remotely from home. As a result, they dealt only with urgent cases. Most decisions on physical transfers were taken on a case-by-case basis, and only a few transfers of prisoners took place, mostly with neighboring countries and on ground, usually by car or over the sea. Whereas physical transfers of foreign prisoners by plane were aggravated due to flight restrictions and closed internal EU borders. On the positive note, the importance for the member states of the EU to be in close communication with each other increased during the COVID-19 pandemic. This relates to what I was saying earlier about one of the critical features of the framework decision, mutual recognition and mutual trust. Turning our attention now to the Lithuanian perspective. As a response to COVID-19, Lithuania introduced its first containment measures on the end of February 2020, which varied between so-called pandemic waves. Measures included a ban on family and other visits, large-scale events, and prison leave. No incoming or outgoing movement was allowed, meaning no prisoner transfers. Returning parole prisoners and all new prisoners, included those who were transferred from foreign countries, were placed in isolation, as were potentially infected persons and their contacts. The Lithuanian prison department even stated that if an institution could not guarantee isolation, it should not accept new incoming prisoners. As a result, usual cooperation in the context of transfer of prisoners was hampered. In 2020, the first, and in my knowledge, the only case to this moment addressing the spread of the coronavirus as a ground of non-transfer of a foreign judgment imposing a custodial sentence reached Lithuanian courts. The sentenced person, who is a Lithuanian citizen, was convicted of a criminal offense, drug trafficking in the Kingdom of Sweden. Consequently, the competent authorities of the Kingdom of Sweden decided to transfer him back to Lithuania for further execution of the sentence. However, the sentenced person filed an appeal. The sentenced person appeal was based mainly on three following arguments. First one, due to the global pandemic, any movement of persons without exceptional circumstances is not justified. Second, Lithuania is in the first place in Europe in terms of the number of people newly infected with COVID-19 infection per day. And third one, publicly available information indicates that this dangerous virus is widespread in Lithuanian prisons. Consequently, the sentenced person tried to prove that his transfer from the Kingdom of Sweden, where conditions for his life and health are safe, to the Republic of Lithuania, there his life and health would be in real danger, would violate his rights and legitimate interests. It is important to highlight that no evidence supporting these arguments were submitted by the sentenced person. At this moment, it is crucial to ask if there was any potential ground for refusal in this case. And since I said at the beginning, the competent authority of the executing state, in this example Lithuania, is obliged to recognize a judgment that has been forwarded, unless it decides to invoke one of the grounds for non-recognition. As we all recall, the sentenced person stated in his appeal that his transfer to Lithuania would violate his rights and legitimate interests. And although he did not directly state the specific ground for refusal of the judgment, his arguments led to the conclusion that there was only one potential one he got in mind. And this ground is directly provided on the slide, actually. So moving on to the key question. So is the spread of the coronavirus solely can be considered a ground for non-recognition of a foreign judgment imposing a custodial sentence? A possible answer will be relieved upon further discussion of the outcome of this case law example. And the outcome of this case was as follows. The Lithuanian Court of the Appeal dismissed the convicted person's appeal by its final decision and stated that the sentenced person is a citizen of Lithuania and his last place of residence is in Lithuania. Consequently, his consent for the Republic of Lithuania to recognize and enforce the Kingdoms of Sweden decision is not required. Therefore, the rights of the sentenced person are not violated in this case. Secondly, after consultations with the competent authority of the issuing state, the Republic of Lithuania guaranteed that his transfer to Lithuania would not violate his rights. To put it simply, the Kingdom of Sweden's competent authorities contacted Lithuanian ones to discuss if there were any risks as regard violation of the sentenced person's rights due to the COVID-19 outbreak in Lithuania, and Lithuanian authorities guaranteed that there were none. And finally, there is no data regarding his social, family, economic, or other links to the issuing member state. Therefore, his transfer to Lithuania will facilitate social rehabilitation and create more favorable opportunities for his social reintegration. Without getting into more profound analysis, I would like to highlight that, in my opinion, this court decision very rightly emphasized the importance of assessing all grounds for transfer without interpreting any one of them as decisive. In this case, the Lithuanian Court of Appeal not only stressed the importance of social rehabilitation as the key aim of framework decision, but also provided an answer to the previously raised question regarding the spread of the coronavirus being a sole ground for non-transfer. It has become clear that recognition of judgment cannot be refused on the basis of COVID-19 situation in the country alone. Perhaps only one aspect does not withstand criticism from my point of view. The content of the guarantee provided by the Republic of Lithuania, which was crucial regarding the situation of the COVID-19 pandemic and its presence, was unclear, or at least was not directly provided in the final decision. Therefore, the doubt remains how exactly Lithuania ensured that the sentenced person's rights were respected during the coronavirus outbreak. So this brings me to the end of my presentation. And to sum up everything up, I would like to emphasize my main points by stating that the temporary suspension of physical transfer of prisoners under framework decision during a COVID-19 pandemic was inevitable and was justified by objective circumstances. And second of all, example from the Lithuanian case law showed that court's decision whether to recognize and enforce another EU member state's decision imposing a custodial sentence cannot solely depend on epidemiological situation of that member state to which a judgment is forwarded. So I hope you find this presentation insightful. Thank you for your time and attention.
Thank you very much. Thank you to the fourth of you. We have something like 15 minutes, no more, for discussion, because then we have a short lunch break and an online conference lecture at 12:30. So please try to keep on brief questions and short responses. I have two online questions. Maybe I can start with that, both for Goda. First one, do you think virtual reality can really reflect and adapt to various aspects, especially unexpected one, for example, late submission of evidence for court proceedings? How about inspection of real live objects which is outside the court during the trial? And the second one, do you personally think EU approach to AI should change?
Okay, thank you. Thank you for both of the questions. The first one was actually a pretty complex, so if I won't answer all of it, you just highlight, some of the... No, you just say if I missed something, because it had a lot of components in it. To answer the first question, I would say that I can see virtual reality as being, used in the near future, because I don't see why it couldn't be used. We already are using it. I know that some countries already are using virtual reality for trainings, for people working at courts. Also I think it could be used for trainings for people who apply to court for the first time and they don't know all the rules and so on. So I think it could be a way, how cases could be resolved in the future. In terms of the specific elements, I'm not sure. I think this question would follow more to the technicians, because in terms of what about the submission of the evidence, I don't know how they will technically, solve this issue, but I don't think that this will be like a major problem. I don't see any major drawbacks or major ideas, or I don't know why virtual reality couldn't be used in the future. So I think we will see that, we will see it in the near future. So, and this was emphasized in my presentation. Now the second question, I liked it very much. It was about the European approach and whether I agree with the European approach.
Do you see that the EU approach to artificial intelligence should change in the future?
Yeah, so I like this question very much because I find it, it is something that I'm interested in researching, the whole European approach, like why it is like that, why, because, on the one hand, European institutions say that we must, we're not keeping up with the USA, we're not keeping up with China, and we must keep up, we must become a leader in the field of technology in various sectors. But on the other hand, we say that we have to do it European way, that we have to ensure all the European values, and it's, when we talk about the European approach, it's always about balance, and I like that because I wouldn't like to live, like in China, for example, where they have the social credit system, where they have this cybersecurity issues and so on. So I think that it is good. I'm happy that we live in that I live in Europe, and that we have specifically this approach, which always puts an emphasis on human rights. But in terms of its change, and answering the question, considering current technological development, I would say that I agree with this approach, and I agree that we must have human intervention, we must have human revision, let's put it that way, because while there are still very widely discussed problems such as the problem of black box, the problem of discrimination, and since these problems are so active and they're not resolved, I wouldn't trust, technology to take full responsibility and to make final decisions. Once we find ways, to overcome these major obstacles, I think that the European approach will change accordingly, because, as I mentioned, they want to keep up. They want us to be the European Union to be leading in this field. So. I hope I answered both of the questions. So thank you for the questions.
I'm sure you did. The floor is open for question. I have no more streaming questions, so maybe you want to start?
I actually want to ask a question. Gola, first of all, thank you for a very insightful presentation. It was very interesting to listen to you. And I was curious a little bit more about the avatar system you were talking about. Because, for example, in criminal cases, judges also have to evaluate the personality of the convicts, of the suspects. And if we're now moving on to using avatars, the question I raised for myself, how is it possible to evaluate the suspect's personality if he is hidden under some kind of avatar? What will be your opinion on that?
Thank you very much for your question, and I think this question is a very good and very precise one, because when we talk about courts, we cannot put in one line criminal courts, civil courts, and administrative courts. So I totally agree with you that in terms of criminal courts, we have to have some other special regulations, special criteria, and and that's thank you for this point, because I didn't emphasize this in my presentation. So it's good that you asked this question. So now I have the opportunity to emphasize that I agree with you that when we talk about criminal courts, special rules should apply there, and this is the main reason why when we talk about virtual hearings, about online courts, we always mostly talk about the progress is mostly seen in civil courts, then administrative administrative courts, and only then we can talk about criminal courts, because the questions that they deal with in criminal courts are, are of extreme importance, and so I hope I answered your question, and thank you.
Thank you. I have at least two questions. You were the first. Maybe you can use the microphone.
Thank you. So I just have a more technical question. What is the current situation with regard to the digitalization of the case files in Lithuania? So are they digital, or are they like traditional? I mean, is it still paperwork? Because it's, for example, a big problem in Poland that we still have paper case files, and judges have to like physically enter courts to start working, and they should not bring them out of the courts, and that's basically it. And the second aspect, what are your regulations with regard to the remote court sessions? So, are you allowed? Is it like free? So, for example, are you allowed to use like privately available like communication sources like Zoom, for example, stuff like that, or you do have a dedicated platform for it? Thank you very much, and thank you for your presentation. It was very insightful.
Thank you. So I understand both questions are for me, so I will try to be short so that others can answer some questions as well. So answering to your first question, which was about the case files. So everything is digitalized in Lithuania. We no longer have, this is the perk of living in a small country. I can only say on behalf of administrative courts and civil courts, and in criminal courts the situation might be different. But I'm mostly researching civil and administrative courts. So there everything is digitalized. We have this Litako system that I mentioned, which is in force since 2004, and a new version was released. So everything is digitalized. So, like I mentioned, the perks of a small country. We don't have maybe as many cases, or as many. The backlog isn't as big. And to answer your second question, which was about the remote court hearings. So again, I can only answer on behalf of civil courts and administrative courts, because the procedure is slightly different in criminal courts. So we only have recommendations. We don't have it stated neither in the code of civil law nor in the code of administrative law. But we only have these recommendations. But it is being debated as of now whether we should, include it, because actually I worked in the Supreme Administrative Court of the Republic of Lithuania. And what was interesting, what I found interesting is that how do you say, not the clients, but the persons people who applied to court, they later on, after after some months of the pandemic, they were asking for remote court hearings. Like, judge, could we please have remote court hearings? It's much more convenient. So, talking from an administrative, Supreme Administrative Court of Lithuania point of view, because this is something where I have some inside information. So even the people who were applying to court asked for remote court hearings. So I would say that it worked pretty well in Lithuania. And the final aspect, which is some inside information, is that for example, administrative cases were finalized. How to say? The backlog was lesser when we had these remote court hearings, and this was a very interesting finding that the courts worked better when we had this pandemic situation in Lithuania. So this is another indicator, that the COVID pandemic in some way, was a good kick, was a good move, And so I think this is that's why the remote court hearings will stay in Lithuania, at least in administrative cases. And also we had the special system. So in administrative cases, we had the special system before the pandemic, but it was only applied to some cases. So I think they are going to expand the system, and we will no longer need, I hope, we will no longer need to rely on Zoom or on Microsoft Teams, and we will have our own system to have remote court hearings. So I hope I answered your question.
Thank you.
Let's catch up
Thank
on
you.
lunch.
Just the last question, 1 minute, answer and question and answer.
Do you have any more questions?
No, you have the last one.
No. So I will use my question. It says the Professor Molch is leaving, and we have very little time, and we have to be very efficient. I please invite you to to go to the main entrance of the Faculty of Law, where we're going to take a picture.
A picture.
Yeah.
So before doing that, I hope you join me to thank all the speakers. Thank you very much. And thank you, Raquel, online.
And after the picture, lunch, and back here at 12:30, 1:30 p.m. Thank you very much. Everyone, once again, I hope you had a great lunch and you're full, but nevertheless ready for more presentations. And we have to make some sort of a little bit amendment, so we will postpone our keynote lecture due to some technical issues. But nevertheless, we will start now with our session 4. So it's questions about private law, globalization, and digitalization. So please, moderators and speakers, please join us up front.
Okay, I am very happy to be in Vilnius again in person, and now we have session 4, entitled Globalization and Digitalization. And our first speaker is Filip Wiaderek, and the title of his presentation is Blockchain and Tacit Collusion, How Smart Contracts Are Going to Kill the Antitrust Law.
Okay, so do you hear me well, even if in the back? Yes, okay, so I'm very happy with it. And good afternoon to everyone. I'm very pleased to have an opportunity to speak to you. And as Professor Namysłowska has already introduced me, I'm a PhD student from Łódź. I deal with competition law both as an academic as well as a practitioner. And the topic of my presentation is, as you can see on the slide, so blockchain and tacit collusion, how smart contracts are going to kill the antitrust law. And yes, the topic is a little bit mysterious, and yes, it is a little bit a legal sci-fi. But when dealing with antitrust law issues, you should not only watch or be concerned about things that create threats for the competition as it is for now, but what may be the upcoming threats for the competition. So I will do my best to clarify those issues the simplest way I can. So just to begin with, I will describe what we will be talking about. So, firstly, we will answer the question: how did and how does technology change modern cartels? So, and in particular, what impact of blockchain technology and smart contract is in this transition, What is more important? How to protect competition from those arising threats. And as introduction is already behind us, so now we will move to brief description of the phenomenon of tacit collusion, because some of you may not be particularly aware what does this notion refers to. Then we are going to talk about the basic characteristics of the blockchain and smart contracts, but we will not get to the details. We will just touch the surface so that we touch those aspects that are relevant for the further antitrust analysis of the problem that I want to address in my presentation. And then we will move to the aspect that I have already mentioned, so how to protect the competition from those threats that may arise. And I hope that I will leave some space for conclusions. Questions will be at the end of the whole panel, but I did not manage to change my presentation before I found out what the exact schedule is. Okay, so with beginning with this issue of tacit collusion, and I assume that every one of you who thinks of a classic cartel thinks of a bunch of persons gathered in a smoke-filled room discussing how to reduce output or how to restrict prices. How to settle prices. And this is explicit collusion. So parties to an agreement agree to restrict competition in certain way. And with regard to tacit collusion, it's quite the opposite. So the economic theory shows us that coordinating market behavior is possible even if there is no direct agreement to do so. So competitors are able to understand that their market position is interdependent between each other, and they can infer that there is a common strategy that is supra-competitive, so they should elevate prices, not decrease them. They should not fight against each other, but cooperate to achieve a collusive equilibrium. And they do it solely by inferring this from the market surrounding, not from entering into any particular agreement. And just giving you some more theoretical background, Nicolas Petit introduced four conditions for tacit collusion to arise. So common understanding of price. So parties of a market players have to be able to identify what the collusive equilibrium is. Secondly, there has to be a credible threat of retaliation, so they have to be able to punish those who abstain from this collusive equilibrium. So if, for example, one of the competitors abstains, so decrease prices in order to get the consumers from his competitors, his price, for example, will be undercut, so a price war starts. And ability to detect such cases of not following this common strategy is one of the key factors. And the third factor is also related to the previous one, so ability to constantly monitor the market. The fourth is not so relevant for the purpose of our further analysis, but its ability to discourage entry, so ability to discourage new potential market participants to enter the market. And I thought about giving you an exemplary case of how an introduction of a certain new technology may soften competition in a particular way. And here I give all my credits to Professor David Pope from the University of Chicago, or in fact anyone who administers his Twitter account, because I'm not sure if he does it personally, but he once recalled a paper mentioning an introduction of simple cell phones in a fishery market somewhere in India. And what happened is that because of this introduction of new technology, which boosted ability to communicate between market participants, as you can see on the slide, prices started to go, higher prices decreased and lower prices went up. So the competition softened. So this is just like basic example how technology may, which fosters communication between market participants, may affect market conditions favoring the existence of tacit collusion. So now we move to more core aspects of the presentation. So what is blockchain? Again, I would just to make a short notice that I'm just touching the surface of those technological aspects. So basically, blockchain is an open and distributed ledger that can record manually or automatically all sort of data exchanged between users. And what is relevant for us is that this ledger, so that this record of information is distributed among the whole chain of blockchain participants. So on the contrary to platform, data is not stored in one particular place, but it's stored all over the whole blockchain, which has some relevant implications for us. So every participant of the blockchain is equal and has equal access to precisely the same kind of market data. Information is immutable, so you cannot delete information from blockchain. It will always stay there. You can only add new information to blockchain, and members of this blockchain are sure that what they see is exactly the same as others see. And referring to this example that I mentioned about cell phones, it's like giving competitors a super phone from which they can call all the market participants at the same time, receive information real time, and they are sure that they are not lied about this information they get. So just to give you an example, what kind of difference in the efficiency in technology we are talking about. So now we move to the issue of what is a smart contract, and they are just, for the purpose of this presentation, of course, we should construe them as computer programs that are executed automatically and according to the encrypted code. And information from blockchain may be encrypted in the smart contract directly. And what smart contracts do to the market is that they increase market transparency in a way that if you know that there are smart contracts and they are performed according to certain set of circumstances or refer to certain data pools, then they will be performed according to those data they refer to. So if you know the data they refer to, you can more easily predict what the market outcome would be. In conclusion, blockchain provides full real-time access to market data for the market participants, and smart contracts create certainty about market conditions, especially market outcomes. And let's move to an exemplary, unfortunately fictional case, but I was basing on my previous cases that I investigated to see how the cases that I investigated could have been fueled by using blockchain technology. So I want you to imagine a market of only a few participants. It could be for example, they could be agri-food wholesalers. They gather market data about weather conditions, for example, which is relevant, of course, in the agri-food market, production outputs from the farmers, and this information is later directly embedded to smart contracts. Those wholesalers enter into with supermarket chains, for example. And they share this information on a common platform that is based on blockchain. One relevant notice on a public blockchain. So everyone technically can access this information shared between those wholesalers. And as you can probably imagine, competitors refer to the same set of data, which is directly embedded to certain contracts on the downstream market. So those wholesalers are nearly sure about the conditions that are offered on the downstream market. So it's a perfect market environment for tacit collusion to arise, because they are sure what they are doing. And where is the antitrust problem is that if you want to apply antitrust rules, so competition rules, to this case study, you would need something that you could identify as an agreement, and it could be problematic to apply the notion of agreement to this set of circumstances. Of course, practices such as exchange of information are applied to instances of exchange of commercially sensitive information. However, there are certain criteria for the information being exchanged to be deemed an infringement of a competition law or be lawful. And in my opinion, there is a problem with how we define what kind of data exchanged between the competitors, about the exchange of what kind of data would result in infringement of competition law. Because we currently are more focused about whether exchange of publicly available data will result, could be qualified as an infringement on competition law. We put less focus on analyzing whether in this particular market conditions, with this particular ability, I mean business analytics ability to process data, we can achieve a coordinated result, anti-competitive coordinated results with this particular set of data. So I think that we need more nuanced and more economic approach to the instances of exchange of information, and that's basically the main point of my presentation. When I see where I see the chances for improvement, for example, draft of new horizontal guidelines, so guidelines on horizontal cooperation between the competitors. And although there is a visible tendency that we are adopting more economic approach, we still make use of those qualitative criteria, like, for example, exchange of publicly available data can rarely be regarded as an infringement of competition law. And that's problematic, and that has to change, because firstly, what do we construe under the notion of publicly available data? Data that is on a public blockchain? I don't know if we can say so, but if an entrepreneur gets an information from the European Commission that exchange of that kind of information would not result in the infringement of competition law, then when he is informed that the data that this pricing algorithm or smart contracts operates is publicly available and according to the Commission, it's totally fine, then it may be problematic with setting clear guidelines, clear rules for the market participants. And we must be aware that we give guidelines for the period of 10 years. If you would tell me that the German Bundeskartellamt would make a case against Facebook for infringing competition rules for processing data information in certain kind 10 years ago, I would not believe it. I would think that this is a legal sci-fi. And that's basically the point. So answering the core question, I think that the proper answer to the question that I said on the first slide, that I posed on the first slide, is following: by improper interpretation of currently enforceable competition rules, by improper interpretation of those rules, we may let technology such as blockchain or smart contracts kill antitrust law. So, but in effect, what we can do is just use those tools that are already available in the way that can safeguard competition and provide good results. So thank you for your attention. Here you have some contact detail to me. If you happen to be in Łódź, you can call me. I don't have an office there, so so you have to call me to meet me. Thank you very much.
Thank you, Filip. And our next speaker is Justyna Zdrakšas from Vilnius University with the topic Digital Exhaustion of Authors' Rights to Distribution. The floor is yours.
Thank you. Dear attendees, my name is Justyna Zdrakšas, and it is my pleasure to speak before you today and address the issue of digital exhaustion of authors' right to distribution. I know that copyright law might not be everyone's cup of tea, so I'd like to start out with a general description of what exactly the exhaustion rule might pertain to copyright law. As a basic, it could be described as a loss control of the chain of distribution after the first legal sale of a work that is being protected by copyright law. In other words, if I write a book and let's say sell it to any one of the attendees of the conference, I can no longer prohibit you from reselling that book to anyone else. I lose control of the chain of distribution and the distribution means. There are certain conditions for this, for the application of exhaustion. Number one being the transfer of ownership through sale or other means. Number two, the legality aspect. The transaction must be made willingly and knowingly. Number three, the transaction must be done and the transfer of ownership be made in a territory prescribed by law. For example, the European Union law requires that the transfer of ownership be made in the European Economic Area in order for exhaustion to be applied. And number four, which is the most perhaps important condition for the purposes of this presentation, is that all copies of the transferred works must be fixed. There must be material. I must be able to smell the parchment of the book that is being sold. It does not apply to digital works. As a result, you may no longer, and were never able, to resell any ebooks that you own, or resell any digital pieces of music, musical files, or digital artwork, and all the other types of works. This, of course, leads to limitation of property rights for the benefit of the copyright holder, because copyright holder must provide his permission in order for further distribution to happen, because it does fall within his rights. And it might also constitute a breach of legitimate expectations of consumers, as of course whenever you buy an ebook, let's say, you might expect that you might be able to resell it later, as is typical with all types of private property. Seeing this at least as a possible problem, at least from the perspective of the consumer, the ECJ tried to approach this question at least a couple of times. Firstly, in 2012, in the infamous Usoft case, where ECJ ruled that the rule of exhaustion does indeed apply to computer programs. Whenever computer programs are being transferred through computer networks or the internet, this rule may apply and digital exhaustion may be applied, which led, of course, to legal scientists to hope that this rule might be applied to all other types of works as well. However, all these hopes were utterly shattered with the Tom Cabinet decision in 2019, when ECJ ruled that other types of works do not even fall under the category of distribution, and they belong to the category of communication to the public, which is a whole separate category of copyright law. Reasons for this were, of course, a little bit different regulations regarding computer programs and all other types of works. Computer programs are being regulated by the directive of 2009 on the legal protection of computer programs, which does not contain rules and does not regulate the communication to the public right, and does not even contain the condition of fixed copies. While the directive of 2001 on the harmonization of certain aspects of copyright and related rights in the information society does and regulates all other types of works. However, taking this into the regard, we might still ask the question whether these different approaches of interpretation were substantiated. And at least in my own perspective, the obvious, or at least most likely, answer is no. In 1996, the European Community, as it was known at that time, signed the World Intellectual Property Organization Copyright Treaty, along with its agreed statements, which explicitly stated that the expressions copies, originals and copies, in the context of distribution, refer exclusively to fixed copies. that can be put into circulation as tangible objects only. Taking into the account that both Directive of 2009 and 2001 should have been explained in the light of this notion, the general answer in both of the mentioned cases should have been the same, that digital exhaustion does not apply neither for computer programs nor other types of works, because the copyright treaty does not differentiate between these. It only supplies a general rule that copies must be fixed, tangible, in order for exhaustion rule to apply. Even having this answer and probable position, we might still ask the questions whether these types of situations fall under the right of distribution or right of communication to the public, as it was relevant in the case of Tom Cabinet. For the right of distribution, it is mostly emphasized that transfer of ownership must be made and indefinite control granted after the transfer of ownership, while the right of communication emphasizes only access of a work and not indefinite control of it, and only accessing it at chosen place and chosen time. Taking into the account the factual circumstances of the Tom Cabinet case, where works might be downloaded from computer websites for an indefinite period of time and acquiring indefinite control of these works, we might come to a natural conclusion that these sorts of situations are more reminiscent of the distribution right rather than communication to the public right, where we can still speak about exhaustion. Even when we come to this conclusion, there still comes a problem of the copyright treaty, which does explicitly, as mentioned before, prevent the application of exhaustion. Even when we consider that transmission of works over computer networks, or to put it simply, over the internet, is considered distribution. Taking this into regard, I believe that currently, at least, there is no other approach than changing the 1996 regulation of the Copyright Treaty and also the 2001 Directive on Informational Society in order to achieve this goal of applying digital exhaustion rule to all types of works, be it e-books or just physical copies of books. However, there comes a problem of policy, of course. I do not mean to go into detail of this. However, we can emphasize certain risks of amending the current model because it does not come only with benefits. We might, for example, ask the question, will the copyright holders lose incentive to sell their works, as primary and secondary markets would be in direct competition in this case? By this, I mean, whenever a physical sale is made, a physical book is sold, there's a natural wear and tear of that book. With each additional sale, the quality of the book reduces, and so secondary markets are not exactly in direct competition with primary markets, where the quality of those books are, well, in their prime. This is not the case in the digital area, where it doesn't matter whether the book is sold for the first time or the 100th time, the quality of the book is still the same. And so copyright holders, be it authors or publishers which might acquire the rights to those works, might lose remuneration and accordingly lose incentive to sell their works or even produce them, because they would not gain the same amount of money for them. The second question that we might ask is, how can we ensure that no more copies of the sold work are made? If with each additional sale, an additional copy would be produced, the market would be flooded with copies of that particular work, and this would also not contribute to solving the problem of applying the rule of exhaustion, as copyright holders might once again lose incentive to produce works, to sell them, and lose possible remuneration for this. The answer to both of these questions should involve certain degree of economic and technological knowledge, and I do not have the ambition as a lawyer to answer these immediately. But what I can say, at least as a consumer, that they are at least worth looking into if we strive to protect property rights and interests of consumers in a democratic society and try to strike a certain amount of balance between the interest of copyright holders and consumers. Thank you.
Thank you. Thanks a lot. And the next speaker is Jurgis Bartkus, and he asked if we can save arbitrators' jobs because of digitalization of international arbitration.
Yes, so hello everyone. I hope you can see my slides. Yes, so today, as you can see from the topic, and as the moderator already told you, I'm going to speak about digitalization of international arbitration. And the question which I always wanted to ask is, how can we save arbitrators' jobs? But before trying to answering this question, we need to understand, well, why do I pose this question at all? And I pose this question because of the challenges that are brought by digitalization to international arbitration procedure. And more specifically, due to the deployment of the artificial intelligence in the decision-making process. And as already in the last panel we discussed, there are various artificial intelligence possible deployments in the judicial proceedings. You can see a couple of examples here. For instance, Estonia is currently developing an artificial intelligence judge that can adjudicate small claims, disputes of less than 7,000 euros, and etc. There are many other more examples. And it's inevitable that these deployments of the artificial intelligence will reach international arbitration procedure to some extent. It might not substitute the arbitrator as such, but it nevertheless can take some of arbitrators' functions in the decision-making process in international arbitration proceedings. And of course, then the question is, well, what kind of implications then do we have due to this deployment of the artificial intelligence? And implications are simple when we understand that arbitrators are market participants. They participate in a very specific kind of market, which is called arbitrating services market. They provide arbitrating services to the parties that wants to submit their dispute to the arbitration. And if there are market participants, at least to some extent, we say that, well, market participants are rational and they try to maximize their own benefits. And what is the benefits of the arbitrators? Well, it's reappointments in the future cases, in future arbitration cases. And meanwhile, the impact of artificial intelligence and in the decision-making process inevitably lead to the reduction of arbitration appointments, workload, and ultimately fees for arbitration services. Because even in part, if we take the decision makers from the arbitrators and put it in the AI hands, well, we have a problem because the workload is reduced. So therefore, the question is, so how can we save arbitrators' jobs in the face of this deployment of the artificial intelligence in the near future? And first, in order to answer this question, well, we have to understand, okay, so what is the difference between the artificial intelligence and arbitrator? Why do we want for the artificial intelligence to replace the arbitrator in the decision-making in some respects? And here I focus only on one aspects. And this is a very simple aspect, that humans, unlike the artificial intelligence, are prone to a variety of cognitive errors in the decision-making process. And here various empirical research, legal studies, have confirmed that arbitrators make the same mistakes as any other human beings. And they're prone or subjected to at least two. There are a lot of cognitive biases, but I will focus on those two in my presentation. So, and first of all is the confirmation bias. And confirmation bias, simply put, leads to a very, very simple thing that, well, the arbitrators tend to believe that information or evidence provided at the beginning of the trial has more influence on the decision-making process of arbitrator than the information provided afterwards. Why? Well, because if you receive the information during the initial stages of the trial, you tend to formulate your own opinion, and then you have a tendency to put all the evidence that's submitted afterwards that are in accordance with this opinion. Another one is framing biases, and this framing biases means that basically not the credibility of evidence itself, but rather the consistency of factual story that is put by one of the parties actually has more importance in the decision-making process of the arbitrator. Meaning that, well, if one of the parties provide a very consistent, vivid factual history of what actually happened in the case, even though the evidence might be not so credible, due to this bias, arbitrator will tend to believe that, well, this factual history is correct and is actually true what happened in the case. So and these cognitive errors lead to the conclusion that, well, is to some extent, even unconsciously, arbitrators base their decisions on factors such as timing, or manner in which the evidence is presented, on the factual history, storytelling provided by the parties, rather than the impartial assessment of evidence. While the machine, artificial intelligence, is capable of impartially evaluating the evidence submitted by the parties without facing any cognitive biases, problems, or any other cognitive problems. So accordingly, the question now, a lot of questions, but the question is now that, so how can arbitrators avoid these problems in the decision-making process? And my solution is the rules of admissibility of evidence. And today we'll focus on only one rule of admissibility of evidence, and this is Article 4, Part 7 of the IBA Rules on the Taking of Evidence in International Arbitration. Those who are not very familiar with international arbitration, IBA Rules on Taking of Evidence usually is considered as the best practice guidelines in international arbitration procedure, even though they're not usually deployed as mandatory arbitral procedural rules. Nevertheless, arbitral tribunals tend to rely on them constantly when the issue of evidence arises. And Article 7, Part 2 provides very simple admissibility rule. Imagine that a party submits written witness statement to the arbitration trial. However, the witness that has a statement is unable to appear before the arbitral tribunal. And what the arbitral tribunal only has is its written evidence. So according to Article 4, Part 7, the arbitral tribunal shall disregard such written witness statement if the witness is not able to appear before the arbitral tribunal, except if there is exceptional circumstances and the arbitral tribunal decides otherwise. Yeah. However, in order to understand the rationale behind this admissibility rule is twofold. So first, in general, legal scholarship agrees that there is a party right to cross-examine a witness. Yeah? And if there is no witness at the evidentiary hearing and you only have a paper of the written witness statement, you don't have a right to cross-examine. You cannot question him. Yeah, and the second one and most important one, we tend to believe that it's unreliable evidence. Why it is unreliable evidence? Well, because it's basically impossible to challenge it. It's impossible to find out whether or not it's true. It's impossible to actually question the witness, whether or not do you think that this really happened, etc., to point to right and wrong directions and so forth. So reliability of evidence and right to cross-examine the witness are the rationales behind this rule. However, the status quo of admissibility of evidence in international arbitration goes a little bit the other way around, actually completely other way around. Most of the procedural rules, including the IBA rules of evidence, tend to say that, well, arbitral tribunals have a wide discretion in the matters of admissibility of evidence, meaning that they can go both ways, both exclude evidence, both not exclude evidence. However, the general approach approved in arbitral tribunal case law and legal doctrine is that, well, it is called the liberal approach towards the admissibility of evidence, meaning that arbitral tribunals, they are a little bit afraid, but not a little bit, they're definitely afraid to apply admissibility rules. Why? They think that a party has a right to present all of the evidence that they want. There is no appeal in arbitration proceedings, and etc. Due to various reasons, this liberal approach is very in the nature of international arbitration procedure. And the case law basically approves this approach and focus not on the exclusion, not on inadmissibility of such evidence, but on the free evaluation of such evidence, meaning that determination of its relevance, weight, and reliability. Meaning that, well, arbitral tribunal will not exclude evidence, but he would say to the party, yeah, give me the evidence and I will assign it appropriate weight, whether or not it's reliable, etc., and see what comes out of it. With regards to the written witness statement, well, it follows the similar approach. So arbitral tribunals tend to weight it and not exclude it. So basically, they do not apply this admissibility rule as written in Article 4, Paragraph 3. And here I quote one of the arbitral tribunal's decisions where a party fails or refuses to produce any such witness, the written witness testimony will not be ruled inadmissible, I emphasize here. But the tribunal is likely to attach a little or no weight to the written testimony. Yeah, so it tends to weight the evidence. I provide in point 3 various other decisions of the arbitral tribunals that follow the similar pattern. With this situation, we arrive in various cognitive problems, as I mentioned before. If the arbitral tribunal decides to admit all of the evidence, they're inevitably faced with various confirmation biases and framing biases. For example, imagine a situation when the written witness testimony is submitted at the beginning of a trial, and it already formulates the arbitral tribunal idea of what actually happened. Even before other party will submit any other kind of evidence, due to confirmation biases, well, arbitrator would tend to over-evaluate the value of such written witness testimony. Arbitral tribunal may already formed an opinion about the factual outcome of the case. And if this written witness testimony is in accordance with its opinion due to confirmation bias, well, it will tend to see, well, let's look, it's in accordance with the case, so therefore it's reliable evidence. Arbitrator might like some characteristic of the witness, for example, his CV, his writing style, and etc., and therefore might tend to believe that written witness testimony is actually a very reliable evidence. Moreover, framing bias. Imagine a good lawyer, one of the party's representatives, puts a very coherent and vivid factual history about what actually happened and put it into one of the footnotes. The written witness testimony actually approves this Exhibit X of the case 00. So therefore, and due to the framing biases, the arbitral tribunals will say, yeah, it's kind of a consistent story, so therefore it's a clear risk of over-evaluating the evidence. So there is a problem. What is the solution? And the solution is stricter, at least my solution, is stricter approach towards the admissibility of evidence. I suggest to read the IBA rules of taking of evidence as it is written, and shall disregard the written witness testimony means declare it inadmissible. By declaring it inadmissible, we avoid all of the cognitive problems that arise when we decide not to admit the evidence. Of course, there is a lot of potential legal problems with this possible solution. One of the first problem is, of course, if you decide to declare it inadmissible basically all of the times, you risk of excluding potentially reliable evidence, because nevertheless written witness testimony to some extent might be reliable, but we tend to forget when we talk about admissibility rules that no legal rule is perfect. Every single legal rule has its negative consequences. Yeah. The second approach is that, well, we have to employ the lesser evil argument, meaning that, well, the tendency is that the written witness testimony is unreliable evidence because we cannot challenge it in the court. Yeah. And the other problem, which is very interesting one, is that, well, even though we say that you should exclude it, we tend to say that arbitrators does not have ability to ignore inadmissible information. Yeah, even if he reads all of the written witness statement, he still will have to think about it all of the time. Don't think about pink elephants. What you're thinking about is pink elephants. Yeah, so that is the problem. However, the only solution to this problem, other than institutional revolution of the arbitration of the arbitral tribunals and arbitration proceedings, is actually the deployment of the admissibility rules in the arbitral proceedings. Why? Because when parties disagree whether or not they should apply admissibility rules, when parties point to the admissibility rules to the arbitral tribunal, and inevitably fix some of their minds and guides them towards the problems of this evidence that are presented, and therefore they might be able more, at least capable to some extent, ignore this inadmissible information. So therefore, that's the end of my presentation. Thank you very much for your attention. I hope that by applying stricter admissibility rules, I helped, and if we decide to apply it more strictly, we can help save at least one arbitrator's jobs. Thank you very much.
Thank you very much. I am so sorry that I didn't mention that you are from Vilnius University, but everyone knows you as the main organizer of the conference. So, and okay, and the last presentation will be provided online, and the presentation is entitled "The Reform of Investor-State Dispute Settlement: A Public or Private Affair," and the presenter is Tembi Pearl Madeleine. The screen is yours.
Pardon me.
Szeged
Are you able to
University
see?
in Hungary.
Are we able to see my slides?
Yes, we can see your slides.
Excuse me, I'm just trying to. Okay. Sorry, I'm just having a. Are you able to see the slideshow or just my screen? Okay, I think I will do this. So I've just got a bit of a technical issue on my side. Why does it?
Oh, it's perfect.
Not sure why. Sorry, just a second, please. Not sure why.
But we see your presentation.
It's just on my side. There's another. I don't know why it's doing this. Please just excuse me.
And see your presentation.
Thank you very much. Please excuse me about that. Okay, so I might just need to leave my video off for a second, and then I will attempt to put it back on just afterwards, if that's acceptable. Okay, so is that acceptable?
We
Can you
can't
hear me?
understand you.
Okay,
Could
now I
you-
will just continue. I will just have to turn my video off for the presentation, and I'll have to put it back on just afterwards.
Okay, thank you.
Please excuse me for that. So good afternoon, and apologies for that. Sorry for wasting your time. So I'm sending you greetings all the way from Szeged. Unfortunately, I'm not able to attend in person, but also fortunately that I'm able to join you virtually. So my dissertation, to give a background, I'm at the University of Szeged. My dissertation is on the investor-state dispute settlement mechanism in the context of the EU-China Comprehensive Agreement on Investment. So the initial idea of my dissertation was to consider the potential impacts of the agreement on investor-state dispute settlement on states in the global south, which of course some would use, would use terms such as the developing states, or more controversially, the third world. So the dissertation now, however, is simplified to focus on the EU and China, with rather a potential analysis on what the agreement, with the impacts that the agreement may have on the global south, post-doc perhaps. And so my dissertation focused specifically on trying to make proposals for investor-state dispute settlement in the context of ongoing negotiations of the EU-China Comprehensive Agreement on Investment. So in my presentation to you, which you've seen in the first slide titled The Reform of ISDS, a Public or Private Affair, I drew from one of my dissertation research questions on the significance of ISDS. So sharing with you the outline of what I will be just shortly addressing, in the short time that we have today, I begin with an overview in which I will share the background and rationale of the paper. And this is obviously through a summary of published literature that supports my research on the reform of ISDS. I will then address the problem through questions that are raised. The questions raised in the paper that I'm presenting draws from literature. Following my presentation on the problems around the reform of ISDS, I will then clarify the aims and objectives of the paper. My discussion includes an analysis of the public and private nature of ISDS that may contribute towards solving the problem on ISDS reform, whether or not to continue with the ISDS mechanism. And then finally, I will offer concluding remarks. Beginning with an overview, some of you may have come across all sorts of caricatures in attempt to somewhat take the emotion out of ISDS debates. In reform debates, characteristics of ISDS reform proposals have been ridiculed, in some cases as Trojan horses, as you see in this caricature, which is one of history's most famous tricks, which we know from ancient Greek history. But also caricatures have been used playing around with the English idiom, a wolf in sheep's clothing, supposing that current reform proposals of ISDS, such as the multilateral investment court following the initial proposals of a bilateral investment court system, both that have been depicted as innocent, but said that once they're accepted, they may have the power to cause harm or to destroy it. And so provisioned in most investment treaties and increasingly in free trade agreements, the ISDS in the most recent years has attracted increasingly critical attention. But what is the problem? So there are various problems. And before I refer to this cartoon, I just need to mention that anti-globalization forces have pointed to the procedural legitimacy crisis related to how ISDS mechanisms, the mechanism itself is administered, as well as to the substantive legitimacy crisis, which is rooted in the very logic of investment treaty law. Moreover, there's a mutual consensus among states to reform the mechanism, but with varying proposals responding to this legitimacy crisis. Sure, it is mostly the global south or developing countries, if you refer to them as that, or whichever terms that you use. This is the group that has borne the brunt of ISDS. And now, as depicted in this cartoon, over here it says, I'm sorry, the secret tribunal finds your nation's laws in contempt of profit. One big concern is the lack of transparency and decisions taken behind closed doors. And this has been picked up by academics in the subsequent years. To address this crisis, scholarship notes the United Nations Commission on International Trade Law Working Group 3, which is mandated to reform the existing ISDS mechanism and alternatives. Whereas the mandate of the Answer to Working Group 3 focuses only on procedural aspects, the counterclaim proposals of states challenge the existence of the system. But it is criticized that not all states are included in the answer to reform discussions. The EU, as an international driver of the proposals to reform the ISDS mechanism, has proposed a redesign of the ISDS system with an international investment court, such as, some of us may be aware of, that in the Canada-EU Comprehensive Agreement and Comprehensive Economic and Trade Agreement, which is expected to influence agreements with other states. This agreement is considered as a break from the current ISDS system by showing the commitment to work together to establish a permanent multilateral investment court, which is described as closer to the area of public law. And it is expected to deliver more fair and objective judgments. Although somewhat a move away from public international arbitration, criticism is that this proposal does not guarantee to address the substantive issues of the ISDS system. And so, as you see in this slide, it seems that some people may have decided to just drop this whole thing, to just drop this entire idea. So the legitimacy debate has for long been viewed as the West versus the non-West debate. But a twist in the plot has now occurred following criticism of the investment chapter of the North African Free Trade Agreement, which we know in short as NAFTA. Now, the United States, Mexico, and Canada have they've updated NAFTA now with the United States, Mexico, Canada agreement, which is also now referred as the new NAFTA, because it largely modernizes this old provisions of NAFTA. In this new NAFTA, Canada has not agreed to the ISDS mechanism. In fact, ISDS will be terminated between Canada and the United States, which was once a big proponent of ISDS. Now that Canada has decided to, if you could jokingly say, pack its bags, and the United States seems to be seemingly standing at the door, the EU is supposedly left hanging. With these differing stances in the West, scholars now write that any attempt to develop consensus on ISDS reform debate and answer trial may now require new alliances to be formed, of which they then suppose that alliances with states that were formerly excluded from what was now described as, or by some described as, the inner sanctum. Due to a lack of trust in the fairness and impartiality of the ISDS model, paradigm shifters now, such as EPSA, which is namely Brazil, India, and South Africa, have progressed with their own termination reform agendas unilaterally. But before we quickly jump to the conclusion that this suggests alliances, I'd like to share with you now what I discuss in this paper, is that in determining alliances, I discussed that what the formerly excluded states would need to address is rather how to reform ISDS by measuring the expected performance of ISDS mechanism, of which then I propose in this paper through a public-private prism. I suggest that the lack of consensus on whether ISDS belongs in the public or private sphere also contributes to our lack of consensus on whether to terminate or to redesign ISDS. To illustrate my point, I refer to one scholar, von Harten. So some scholars such as him suggest that to redesign ISDS, it must be, they then have to, suggesting that one would need to answer the question in that, is it independent, fair, balanced, and respectful of domestic institutions? Now, I'd like for you to think about it for a second. Of which now they then address, if it does not meet this independent, fair, balanced, and respectful of domestic institutions, then you see that the answer is no, and then suggest then it is preferable to terminate ISDS. What is the problem with this question? Now, the problem is that international arbitration is often characterized as an exclusively private dispute resolution mechanism, as international tribunals do not operate as part of a coherent and unified world government. So to expect the ISDS system to be respectful of domestic institutions somewhat makes the proposal for ISDS to have public characteristics. Comparisons are also drawn between investment treaty system and other subfields of public international law that concern a state's right to act and regulate domestically, such as trade, for instance. And as we know, to reform ISDS, the investment court system and the later multilateral investment court which was proposed are proposals of a semi-permanent court, which, as we know, have been reported to be largely inspired by the World Trade Organization dispute settlement system. But these proposals do not do away with private ISDS mechanism itself. Rather, they allow investor-state arbitration to operate in the context of a permanent or semi-permanent court system. This rather than suggests a public-private hybrid. So a public-private hybrid then may possibly not lead to a clear yes or no answer to the question which I've now shared: is ISDS independent, fair, balanced, and respectful of domestic institutions? And so now we're not clear on whether to redesign or terminate the ISDS system because there's a hybrid. To now bring us to our conclusion, yes, historically, there has not been a public-private distinction, perhaps explaining this reversion to a hybrid international investment regime between public and private that we witness today. The paper highlights that the hybrid makes it difficult to determine the criteria upon which to measure the expected performance of ISDS mechanism and to how to reform it, as I've explained in the previous slide. This lack of consensus on whether ISDS is private or public is what I then say in this paper is contributing to us going backwards and forwards on what to do with ISDS, whether to terminate it or to redesign it. And so now we are back to square one, because we do not know whether to terminate or to redesign ISDS. Will we even know, how to even do it? Because we do not even know whether or not it is or it should be public or private. Thank you. And I'll be open to any questions or suggestions.
Thank you very much. And now we have time for questions and comments. We don't have any online questions, so maybe... Okay, Karin.
Thank you so much for your presentations. I absolutely was so much impressed by yours, but Justinas, you left me hanging, you left me wanting more, and because I understood your topic better than the other ones, possibly. So, have you ever went through any research that the European Commission has enacted, for example, an impact assessment, an ex post thing? Because remember, in my case, so after 22 years of the directive, there has been an ex post evaluation, it failed, and I'm just bamboozled whether did the Commission actually does not see any issues with this, because it's a super relevant topic. Thank you.
Thank you for your question. Just to answer it briefly, I did look into it, whether any official assessments were made, and I have to tell you that no, European Commission has not went into it, and no official analysis has been made. There are some private ones, like not legal, but rather economic scholars did touch upon this, and there are arguments in favor of applying exhaustion rule in the digital area as well, through the economic lens, answering that rights holders might not lose the incentive, even if we apply this rule, but these are only private analysis.
No, I'm good, thanks.
Thank you very much for everyone, for the panel. The presentations were great. So I have questions for more of you, but first to Philip. We're hearing a lot about, regulation of blockchain, and especially in the context of cryptocurrency. But I'm not so sure and so aware of where we are at the moment in the regulation. I know that, for example, some platforms like Binance has got a lot of slowed down the business in Europe. But where we are at and in what level are at the moment the regulation of blockchain and these platforms are, what's happening at the moment?
For the time being, just to provide a vivid parallel, it's an uncharted area. Uncharted waters. But I may just give you how the academics present how the where is the academic discussion. So, for example, with regard to blockchain and competition. So, in 2017, I think there was a roundtable competition policy meeting at the OECD, which discussed on which specifically blockchain and competition issues were discussed. And I just, in my presentation, I picked to be precise, I picked such scenarios that I think might be the most comprehensible ones and most probable ones to occur in the nearest future. But there is also a huge academic discussion about, for example, collusion happening within private blockchains referring to cryptocurrencies, for example, and stuff like that, to put it this way. So to answer your question, I don't know if there is regulation, if there is something else than a discussion, academic discussion about a need of a regulation. And with regard to this academic discussion, it covers a variety of aspects, from fueling traditional methods of collusion by using blockchain-based solutions, and this is what I was talking about, and also to also collusion within blockchain-based industries, like, for example, cryptocurrencies. There is a professor on Sorbonne University, his surname is Schreppel, I think, and he writes extensively about that. So and maybe my point was the point of my presentation was I would like just to highlight it, that to show that there are certain aspects of these problems that I mentioned that can be solved, in my opinion, by existing competition rules, but we have to readjust the way we think about them, and that's all. I hope that I answered your question.
Yeah, I think it's a very complicated issue anyway. Yeah, of course it is.
Thank you.
Thank you. And another question is for Jurgis. You know, I'm always I'm promoting a lot, you know, fundamental rights, and I'm thinking about that the very aspect of, you know, because there was you made a strong point about the biases that arbitrators hold, and isn't it this humane factor that is actually going to save the arbitrator's job if we compare it to AI?
Well, the humane factor is killing the arbitrators' jobs because of the how to say, it's quite evident that we're not capable of everything, and we are making mistakes. We're not acting sometimes rationally, and we are prone to various cognitive errors in our decision making. We tend to over-evaluate our abilities, and etc. So therefore, it's inevitable that we have to fight with our errors, and the law, in this case, precise legal rules, admissibility rules, allows us to fight with them, at least to some extent, and put the decision making of human being at least in the same level as artificial intelligence, or at least try to put it on the same level.
I have a follow-up, if I may, for Jurgis then. Do you rely on the theory, the presumption that there is one correct answer to any case? Because on the other part, for example, what I'm analyzing is that Posner suggests wealth maximization, the formula that includes reduction of human error in the cases, and that would be achieved, for example, including expert testimonies, reading laws pragmatically, and so on. And Posner, I saw, at least you quoted him, the economic analysis of law, he relies on the fact that there is no one correct answer, but the key point is to reach the highest possible best outcome out of it. And I bet that AI is lacking of that factor, because AI would reach one and quite the same decision without analyzing the context. So I would love hearing your views on it.
Yeah, so I think this discussion of whether or not there is one and single and right answer in law is more or less related when Posner, Dworkin, and other authors talk about this, is the question about whether the law provides one single and right answer. Here we're talking about factual circumstances and establishment of truth in the civil or arbitration proceedings. And the answer is whether or not there is one single truth. The answer is no. There are no objective truth to be found, even though it might be a very, very nice thing to say that the courts of arbitrators try to develop and establish objective truth. What we have to follow, in my view and in Richard Posner's view, is that we only establish formal truth. And that's about it. But why do we establish? Because we don't have a means to establish every single kind of evidence. We have other principles in proceedings, such as principle of efficiency, principle of cost benefit, that proceedings should be not so costly, and therefore they'll determine that the arbitral tribunal cannot go throughout the whole 6 months or 1 year to establish all single factual circumstances in the case. So what we have to do is limit ourselves to only formal truth, as your quoted Richard Posner suggests.
Yeah. Can you hear me? Yeah. Thank you all for your great presentations. I've got a follow-up question too. Regarding the potential disappearance of arbitrators, don't you think it's similar to what Schumpeter developed, like the creative destruction, meaning that because of evolution and technological evolution, well, previous jobs will disappear to have new jobs that adapt to that kind of evolution. And rather than disappearing, is it not just the evolution of their role as other actors in the justice sector, such as judges and prosecutors, with that kind of software and artificial intelligence? So rather than really disappearing, their role on is the role of the arbitrator not going to evolve and be some kind of guardian of the procedure and make sure that what the artificial intelligence says or the software that is there is correct, rather than really being absent of that kind of procedure?
Yeah, thank you very much for your question. Unfortunately, it's definitely very hard to predict the future. No surprise. But my sort of view on the issue is that when we talk about the substitution between the artificial intelligence and human beings, is that the arbitrators or justices, we have to think very carefully about changing actually anything. And if we want to deploy artificial intelligence or any machine in the judicial proceedings, we have to really look into it whether or not it would not cause more damage than actually we get the benefits out of it. And I think here I will look at this issue as ultima ratio, and I will definitely not support any changes, at least in the and what most importantly in the decision-making process. So what did Goda told us about in the last sessions about the EU approach, where the artificial intelligence should not be left as a sole decision makers. I completely agree and in line with this European Union approach.
Okay, thank you. First of all, I would like to thank the speakers for your insightful and thought-provoking presentations. And now we have a very short break because at 2 o'clock, yes, at 2 o'clock we start with the keynote speech. So 6 minutes for coffee. Thank you.
Short break. So, due to some changes now, everything I think will be okay. As of now, at 2 p.m., we will be having a third and our last keynote lecture called Artificial Intelligence in Medicine and the AI Act. And keynote lecture will be delivered by Associate Professor Dr. Sebastian Scholz. He's from University of Graz in Austria. And we're happy, very happy that he agreed to deliver the last, but not least, keynote lecture. And with regards to the other session, so we will be having for 20 minutes the keynote lecture. It will end presumably at 2:20 p.m. And as planned, and at 2:30 p.m., we will have our last session on climate change. Yeah, so we will have that 10 minutes, another very short coffee break. But nevertheless, if Sebastian is with us, the floor is yours.
Yeah, thank you very much. Can you see my slides yet?
Yes.
Okay. Just a minute. So, perfect. Thank you very much. Thank you so much for the very nice introduction. It's a great pleasure and honor for me to give a keynote speech at your conference today. Of course, I would have loved to be here with you in Vilnius, but unfortunately this was not possible due to different reasons. However, I'm happy to be able to join you online this way. My topic is artificial intelligence in medicine and the AI Act. In the following, I will use the common abbreviations and speak of AI in medicine and the AIA. First of all, please allow me to give you a brief overview of the content of my keynote. I will start with the background, the objectives, and the core content of the AIA. I will then show that the AIA does not contain specific provisions for medical AI, but that as a general rule, the provisions on high-risk AI are applicable. Afterwards, I will turn to the relation and interaction between the AIA and the MDR, which is the medical device regulation of the EU. Here, I will focus on possible overlaps in scope between the AIA and the MDR, as well as innovations brought about by the AIA. I will conclude then with some remarks on the strengths and weaknesses of the AI from my point of view, especially of course, with regard to medical AI. So I will start out with the background, the objectives and the content of the AI. The publication of the proposal for an AI regulation, which is what the AIA is so far, is of course not an isolated event. It must be seen in the context of a long-term AI strategy of the EU in general and the EU Commission in particular. I will now only mention a few important steps in this development. The Commission has been actively promoting research in the field of AI since 2004. In 2018, the Commission published in the form of a communication the European AI strategy. The Commission then established the independent high-level expert group on artificial intelligence, which presented ethics guidelines for trustworthy AI in 2019 and an assessment list for trustworthy artificial intelligence for self-assessment in 2020. in 2020, the Commission also published a white paper on artificial intelligence, which was followed by a public consultation with a large number of comments and contributions all over the world. Finally, as we all know, in April 2021, the Commission published its proposal for an AI regulation, the AI Act, which of course took into account considerations from many previous documents. In the Commission's words, this is the first ever legal framework for AI that addresses the risks of AI and enables Europe to play a leading role globally. As the Commission states in the first recital of the AI Act, the aim of this regulation, I quote, is to improve the functioning of the internal market by establishing a single legal framework, in particular for the development, marketing and use of artificial intelligence in line with the values of the Union. The following sentence in this recital states, this is again a quote, that the regulation pursues a number of overriding reasons of public interests, such as a high level of protection of healthy, safety and fundamental rights, and that it ensures the free cross-border movement of AI-based goods and services, preventing member states from introducing restrictions on the development, marketing and use of AI systems unless they are explicitly authorized by this regulation. This brings me to the main or the core contents of the AIA. The Commission follows both a horizontal, also a non-sector specific, and a risk-based approach. AI applications are, according to this risk-based approach, divided into 4 risk classes. This is the prohibited AI, high risk AI, low risk AI, and minimal risk AI. This risk-based approach follows the logic: the higher the risk, the higher the legal requirements for the use of the AI system. Unacceptable risk practices are being banned outright. This is also very important. So I turn to the questions of what the AI stipulates for medical AI. Here I have to say that medical AI systems are not assigned a specific risk group a priori. However, the end result is that the rules for high-risk AI are applicable to virtually all medical AI applications. Please let me explain the reason for that. According to the classification rules for high-risk AI systems, a system is considered high risk if it is both intended to be used as a safety component of a product or itself a product covered by the Union harmonization legislation listed in Annex 2, and B, that product is required to undergo a third-party conformity assessment with a view for the placing on the market or putting into service of the product pursuant to the Union harmonization legislation listed in Annex 2. So according to Annex 2 of the AI Act, the MDR indeed is such a listed piece of legislation. Given that, in principle, all medical AI systems qualify as a Class 2A medical device, a third-party conformity assessment would be required according to the MDR. This results in a classification as a high-risk AI system, irrespective of the actual risk of the AI used, as long as the AI system is to be placed on the market as a medical device. This is, of course, associated with a whole range of legal requirements for the providers of such an AI system, which I will discuss briefly in a moment when talking about the relation of MDR and AI. So let me come to this point. When dealing with the relationship or the relation between MDR and AI, it should first be mentioned that the provisions of the MDR remain fundamentally unaffected. In principle, the provisions of the MDR and the AIA apply side by side. So if we look at the content of the two regulations, we quickly notice various overlaps in the regulations. Both regulations require, for example, risk quality management systems, technical documentation, transparency, and provision of information to users, conformity assessments, and some sort of corrective actions. But on the other hand, we can also find some innovations brought up by the AIA, as I already mentioned. First of all, I want to highlight the area of data and data governance. Namely, according to the AIA, AI systems using techniques involving the training of models with data shall be developed on the basis of training, validation, and testing data sets that meet special quality criteria. This is very important, but because this is also not already laid down in the GDPR. And furthermore, data sets shall be relevant, representative, free of errors, and complete. It's important to note that no similar regulation can be found in the MDR. The second remarkable innovation is the requirement of human oversight, which is explicitly laid down in the AIA. AI systems thereby shall include appropriate human machine interface tools so that they can be effectively overseen by natural persons. Also here, we can say that no similar regulation is obtained in the MDR. So this already brings me to the conclusions, and I want to repeat and mention the strengths and weaknesses of the AI Act, of course, with a special view to medical AI. First of all, the strength is that the AI Act includes an AI-specific horizontal regulation, which for itself is already a big achievement, I think. Then we have the points of data governance and human oversight, which are real innovations, as I already mentioned. On the other hand, we have some weaknesses, and I have to say that I only mention a few now. There could be mentioned even more. We have an ambiguity in the various definitions in the AI Act. So it's already very questionable what is AI under the AI Act. That's not very clear and is already criticized in literature, of course. And then we have some doubling and over-regulation problems. As already mentioned, you need aftermarket control for AI medical devices 2 times, 1 time from the perspective of the MDR, on the other hand, from the perspective of the AIA. And an additional problem I want to mention is that we don't have specific rules for medical AI in the AI Act. And I have to add that we also don't have specific rules for medical AI in the MDR. So for the future, it would be really desirable to think of specific rules for medical AI, because they are, in my opinion, missing in the today's legal framework of the EU. So thank you very much for your attention.
Thank you very much, Sebastian, for a very interesting speech. And as of now, we have a 14 minutes break, and we will start at 2:30. So a little bit longer than presumed. So have a coffee break, and we will be back in 14 minutes time. Okay, so I hope that everyone is energized after the coffee break. And hello. So we saved the best for last. Session 5, questions about law and climate change issues. Please, moderator and panelists, join the front.
Good afternoon, everyone. My name is Indra Žvaigždinienė. I'm from Vilnius University, and I'm really proud and honored to be moderating this session, the last session, on climate change, sustainability, and other environmental issues, especially keeping in mind that on Sunday, on the 5th of June, we have the International Environment Day. So it's very symbolical to finish the conference with a session like this. To give an introductory note on sustainability, just a few sentences. Sustainability, everyone knows, it's sort of fashion, as well as a necessity. It's a very wide concept, and as wide is the list of topics that will be covered in this session. So, without further delay, I give the floor to Dalia Kubiliūtė to present a very interesting topic on financial sector and European and sustainability objectives. So, Dalia, please. I will.
Hello, thank you for inviting me for this conference and accepting my presentation. My topic today is European Union Financial Services Law and Sustainability Objectives. In general, sustainability term and ESG, environmental, social, and governance principles are pretty known in public. Especially when the discussions are about the climate change or the current geopolitical situations. With this presentation, I am focusing more about the relation between sustainability objectives in the financial sector, and my main topics are sustainability objectives in European Union policy, environmental considerations in financial services law, sustainability-related disclosures in financial services sector, and Greenwashing Institute. To begin with, in 2015, General Assembly of the United Nations agreed on 17 Sustainable Development Goals that were supplemented by 169 targets, and as it is highlighted in the agenda, and what could be considered as the main sustainability objectives are people, prosperity, partnership, peace, and planet, or in other words, known as 5 Ps. In my topic, the attention is paid to the 13th goal, which is about climate change, and which states that take urgent action to combat climate change and its impacts. In the same year, the international treaty, which goal is to limit global warming below 2, preferably to 1.5 degrees Celsius, compared to pre-industrial levels, was signed by 196 parties in Paris, and it's a well-known agreement, Paris Agreement. European Union, focusing on the world's highest environmental standards, joined the agenda and the Paris Agreement. And to put its will to take the lead among the countries concerned in achieving these global goals, European Union set ambitious sustainability targets for the member states. And in 2016 communication called Next Steps for a Sustainable European Future, it is emphasized that the goals are an integral part of European Union's policy, and the general thesis are listed how European Union would pursue the implementation of the global goals through political, economic, and other means. And in 2019, the European Union adopted the communication, well-known European Green Deal, by which it is expected that the member states reduce CO2 emissions by 40% in 2030, achieve the zero net greenhouse gas emissions in European Union by the year of 2050, and achieve that economic growth would be unbinded from resource use. And to achieve these goals and turn the policy into actions and legal commitments, European Union has undertaken legislative reforms in various sectors: transport, energy, agriculture, and the finance sector as well. And for this, European Union has also adopted a number of laws in several years to implement the principles of global goals into policies and mitigate the negative effects of climate change. And as to mention, one of the key factors influencing the implementation of the Sustainable Development Goals in European Union policies and mitigate the negative effects of the climate change is the financial sector as well. And the question is, why the financial sector? I would note these reasons. First, financial sector may help to finance the necessary changes to direct public and private capital to green projects and to overcome the so-called green finance gap, which is the lack of sufficient financial resources to be directed towards green investments. And the second, public funds are not enough, and to foster the flow of private capital would make a significant impact to sustainable investments, to sustainable and green projects. What is more, the latest researches show the rising awareness of private investors on the environmental, social, and governance issues, targeting goals beyond maximizing profits and minimizing risks. This is a growing trend around the world and among the investors, which has generated large inflows of assets into ESG funds in recent years. And in this regard, European Union imposed additional regulatory requirements regarding the disclosure of sustainability information for the private financial sector and the financial market participants. Sustainable finance covers both financial support for sustainable projects such as Next Generation EU, which also impact sustainable recovery from the impacts of COVID pandemic, and legislation for sustainability-related disclosures. European Union legislation on sustainability-related disclosures or reporting covers banking and financial service providers, that is management companies, insurance companies, or companies that have pension funds, for example. By this regulation, the obligation for financial service provider to disclose sustainability risks for end investors are set, and it is expected to mitigate the risk of greenwashing and misleading the end investors. Sustainability disclosures does not mean that the financial market participants are required to establish sustainable products. However, that implies an obligation for the financial market participants either to disclose sustainability-related risks or to provide the clear reasons why they are not planning to disclose this information. This principle is called comply or explain. It could be said that European Union regulation on the next thing I want to say is about the legal acts that regulates the disclosure requirements. So it is well known Sustainable Finance Disclosure Regulation, or SFDR, which sets mandatory rules for the financial market participants to disclose sustainability risks by entity and by financial product. According to the regulation that came into force last year, this year, the financial market participants already have to collect the information for previous year and provide it to the regulatory institutions. SFDR is supplemented by the regulatory technical standards. These standards provide technical information how information should be disclosed by the financial market participants. The legal uncertainty here is that technical standards will come into force probably next year, but financial sector participants already have to implement the SFDR provisions. And therefore, to solve this problem, European Securities and Markets Authority recommended still to use the technical regulatory standards for the financial market participants. The other one well-known document is taxonomy regulation. It was adopted to supplement and change a little the SFDR. Taxonomy regulation establishes a classification system which provides business with a common language to identify whether or not a given economy activity should be considered as a environmentally sustainable. It sets 6 environmental objectives to which the company providing sustainable finance product must comply. And the taxonomy regulation is supplemented by the delegated acts. However, currently only 2 environmental objectives are, which is climate change mitigation and climate change adaptation, are covered by the taxonomy regulation and the delegated acts. And there is still some uncertainty when the other objectives will be specified. What is more, taxonomy regulation is also a little criticized in legal discourse because it covers only environmental objectives. Having in mind that according to SFDR, sustainable investment products are products that integrate sustainability or environmental, social, and governance considerations, the research just misses the information about the other 2 principles, social and governance. And the last topic I would like to present today, it's about greenwashing. In general, this term is not new. However, regarding the financial section, it was first introduced in the taxonomy regulation in its preamble. The greenwashing means the practice of gaining an unfair competitive advantage by marketing a financial product as environmentally friendly, even though such product is not green. And about the Greenwashing Institute, I think that it would be good to notice these 3 features of the greenwashing. So firstly, it is challenging to identify the greenwashing in the financial sector because it is not that obvious like other types of greenwashing, for example, paper cups that are covered by plastic, or green labels that does not mean the product is green or environmentally friendly. By its nature, greenwashing is a subjective and is subject to interpretations, because there is no concrete regulation or types of greenwashing set. Greenwashing may be observed after completion of internal audit of the financial service participant activities. It is an interesting example of greenwashing in the financial sector that recently occurred. This week, media was full of information that one well-known German bank subsidiary was accused for misleading the investors, providing information that the investment products are green. However, even if they are green, the percent of sustainable activities is very low. The information was provided by the whistleblower, and there is not that much information which is public for now. But this case shows that the greenwashing do exist in financial sector, and it is believed that there will be more such cases in the future. Also, researchers specify such types of greenwashing that may be good or maybe not would be helpful for solving such cases. The concepts of and forms of greenwashing, for example, a claim of greenwashing, which means using textual arguments that explicitly or implicitly refer to the ecological benefits or a product or service to create a misleading environmental claim. Executional greenwashing, a strategy of greenwashing suggests nature-evoking elements such as images using colors or sound or natural landscapes. Selective disclosure, which means poor environmental performance and positive communication about the environmental performance. And greenwashing as decoupling. This is the greenwashing with symbolic actions. When in order to satisfy a client requirements in terms of sustainability, some minor green purposes are emphasized, but without any concrete action. And to finish my topic, I noted four sentences for conclusions. Maybe I would stress this one, that currently the private financial sector is at a juncture of legal and regulatory developments where the European Union sustainable finance policy creators do not draw clear limits to what extent financial services laws and national legislators can pose burden to financial market participants to implement the sustainability-related matters into their activities. And having in mind the recent events, I also noted the fifth concluding sentence, which is a year ago there was a saying among the sustainability and ESG researchers that sustainability matters is like an elephant in a room, meaning everybody knows importance of it, but no one takes or don't want to take real action for it. However, the events of the past several months and even this week show that sustainability matters and the regulation is keeping pace. And therefore, there is no time left for business to avoid disclosing sustainability risks. And since the regulation is new and there are no retrospective studies performed or data collected, the main sources to support the regulation, its interpretations, are the analysis and research performed by the science and by the researchers. So, thank you.
Thank you, Dalia. Thank you, Dalia, for a very interesting presentation on sustainability aspects in financial sector. And now I'm especially pleased to invite to take the floor Dmitry Korchagin, representing Vilnius University as well as Dalia. And he will be, I'm a supervisor of his doctoral studies. That's why I'm especially proud and happy to see him here. And the topic is really very interesting as well. The influence of contemporary crises on sustainable development. Whether sustainability will remain just a beautiful idea or will it help to fight these crises? So, Dmitry, the floor is yours.
Thank you. Dear colleagues, my name is Dmitry Korchagin. I'm a first-year PhD student at Vilnius University, Faculty of Law, but originally I'm from Ukraine, so I wanted to say thank you all for supporting my country. It's very important for us in this time. And in my today's presentation, I would briefly talk about the influence of contemporary crises on sustainable development goals. And as we know, in order to fight the consequences of destructive human-made activity and ensure social, economic, and environmental stability, in 2015, the UN member states adopted a very ambitious 2030 agenda with 17 sustainable development goals. Like from the formal point of view, the legal contours of the 2030 agenda, they are quite narrow. Because the agenda was adopted as a resolution of the UN General Assembly. That's why it lacks the means of enforcement and binding effect itself. As we can see, despite this fact that it wasn't binding, the Sustainable Development Goals have been the important blueprint for policymakers in the recent time. However, as we can see, the world has dramatically changed since 2015 when the Sustainable Development Goals were firstly introduced. Therefore, I find it super important to analyze what sustainable development currently means from the kind of evolutionary perspective, what the main current threats to sustainable development goals are, and whether it's still relevant to follow and implement sustainable development goals in light of the new crises in a changing world. So basically, the concept of sustainable development had not emerged at one time, but it was rather a result of a long-lasting debate between the need for development and the awareness of the importance of environmental protection. And therefore, the idea of sustainable development has been evolving gradually, and in fact, it's still being evolved even right now. So in the history of sustainable development, we have come through Stockholm Conference in 1972, Brundtland Commission and Brundtland Report from 1983 and 1987, Rio Conference in 1992, different follow-up conferences, and finally two Millennium Development Goals from the year 2000 and subsequently two Sustainable Development Goals in 2015. In June this year, the Stockholm Plus 50 conference is to be held in Sweden to commemorate the first ever conference, international conference on human environment, where the ideas of environmentalism and further sustainable development emerged. So the evolution of the concept of sustainable development was going through several phases, and in fact it was the transition from what sustainable development is and how it can be achieved based on what principles, and to what concrete actions we should make to achieve it. Therefore, the real current meaning of sustainable development is that this concept remain quite important without the specific set of goals for its achievement. And for now, it's like sustainable development goals for the moment. Therefore, the current definition of sustainable development should be a development that meets the needs of the present without compromising the ability of future generations to meet their own needs by accommodating the Sustainable Development Goals as the most comprehensive and scientifically approved set of goals for the moment into real life, using different instruments and including legal ones. So as we know, the 2030 Agenda is like a 17 universal global interlinked set of goals, and we now can see what policy what policies are covered by the 17 Sustainable Development Goals. It's not something new. I'm sure you have seen this many times. But however, as we can observe, the current reality sends us very stressful challenges. And I would like to stress out some current threats for Sustainable Development Goals. The first one is the state of climate emergency. As of 2019, more than 11,000 of scientists from around the world stressed that planet Earth is facing climate emergency. And this state of climate emergency directly affects at least one goal, the goal number 13, climate action. The second threat to sustainable development goals, it is the COVID-19 pandemic. We are dealing with plastic footprint, disrupted economic activity, vaccine inequality, etc. So this threat affect the really wide set of sustainable development goals, not only one goal. It can be the goal 8, economic growth, goal 10, reduced inequalities, etc. And the last but not least threat for sustainable development goals is the unprovoked Russian invasion to Ukraine. The war itself brought air pollution with hazardous substances after shellings, affected protected areas, disturbed wild animals, a threat of a complete extension of the Sea of Azov, the economic recession of 133 countries, decline of the global economic growth, food shortage, refugee crisis, so you name it. Just it affect the wide range of sustainable development goals as well, from the goal zero hunger to the goal peace, justice, and strong institutions. And after identifying these challenges, I want to briefly analyze whether it's still relevant to follow the sustainable development goals in light of these newly emerged crises. So, like the first question, is it still relevant to follow the Sustainable Development Goals in the time of climate emergency? And like super brief answer is yes, of course, but I want to use the practical experience from the European Union. I think European Union is kind of a pioneer in this sector, because in 2019, the European Parliament adopted a resolution about climate and environmental emergency, saying about the need to do some actions before it is too late, and not really waiting long in 1 month. In December 2019, the European Union proposed the European Green Deal. It's a very ambitious plan to make the European Union climate neutral and adopt new legislation from circular economy, innovations, biodiversity, and to other associated areas. Therefore, with this initiative, the European Union has shown its adherence, commitment, and the real example that even in light of such crisis, it's still relevant, it's still possible to follow the Sustainable Development Goals and at least to implement one of them, the goal number 13. And the next question was, is it still relevant to follow the Sustainable Development Goals in the post-COVID world? So the brief answer is also yes, but due to the fact that these threats from after the COVID influence not only one Sustainable Development Goal, but a really wide set of goals, we need to use some expertise to understand if it's still relevant, if it's still achievable, aim to follow the Sustainable Development Goals. And I would like to use the expertise of the United Nations. In 1991, United Nations Development Program proposed a report, Leaving No One Behind, impact of COVID-19 on Sustainable Development Goals. And they stress that the impact of COVID-19 on the Sustainable Development Goals shows that the 2030 Agenda remains relevant as a blueprint for targeting investments for the socio-economic recovery. And the main finding of the report was that countries can not only recover from the setback caused by COVID-19, but can accelerate their progress on a range of SDGs targets on poverty, nutrition, etc. Even though many countries may not reach several of the Sustainable Development Goals by 2030, a renewed focus on the 2030 Agenda in COVID-19 recovery efforts would bring them ever closer to achievement, which means that it's important to highlight that even in the light of COVID-19, the following Sustainable Development Goals remains an important blueprint for countries, and it's not only a need, but it mostly like scientifically anticipated possibility to reach some of them in due course. And finally, the last but not least question, is it still relevant to follow the Sustainable Development Goals in the light of the Russian invasion to Ukraine? It's hard to use the brief answer yes or no here, because in case of the war, it's hard to propose like any concrete particular means for the SDGs preservation. So to say they are now relevant or achievable, since the destructiveness that the war brings goes like against the peacekeeping matter, the peacekeeping idea of the Sustainable Development Goals. And due to the fact that this war is like the biggest war on the European continent since the World War II, there are no any templates or agendas or how to cope with its consequences, all the more to follow Sustainable Development Goals at the same time. However, there are some political initiatives in Ukraine on the table on how to at least try to restore its ability to immediate development and the consequence to sustainable development. These political initiatives are really connected. The first one is the mechanism for reparations for environmental damage due to the Russian aggression. It's been developed by the Ministry of Environment of Ukraine. There are a lot of information about this mechanism yet. It's been developed only, so it's something really new. And also the Ministry of Environment of Ukraine recently developed a particular methodology for calculating the amount of pollutant emissions for the atmosphere from Russian bombing. So I think there is a big hope that these initiatives would be really helpful for Ukraine. Besides these mechanisms, they are being developed for now for the first time in history. That's why they could be available for global application in the future in case of any potential extraordinary scenario. So after their implementation and after the restoration of peace, it will be only then relevant to talk about the achievement of sustainable development in the Ukraine. But at the same time, the Russian aggression, in fact, showed that sustainable development is not only possible, but also irreversible process. With the war, dependency on Russian fossil fuels for the world is not viable anymore. And the world has now like full understanding that the gas and oil blackmail from Russia is out of the agenda completely. And for example, recently, Ursula von der Leyen recently noted that the geopolitical reasons are now evident and we must accelerate our clean energy transition. Unfortunately, we already have in place the means to do so. The European Green Deal is already ambitious, but now we are taking our ambitions to yet another level. The European Commission presented a Repower EU, 300 billion euro plan to phase out Russian fossil fuels and fast forward the green transition. So it means that basically the war brings a lot of problems for achievement sustainable development goals for Ukraine as an individual country, but for the rest of the world is an opportunity to finally get rid of Russian fossil fuels for better achievement of sustainable development goals and to properly start this green transition. And in conclusion, I would like to highlight that even without the COVID-19 pandemic, without the state of climate environmental emergency, the war in the heart of Europe, the following sustainable development goals have never been a super easy task. But with new challenges, we understand that we were thrown back in time for reaching sustainable development. That's why we now need to clearly think about what can be practically done to keep this path and this phase for more sustainable future, keeping implementing sustainable development goals. And we can see that ongoing crises demand even more practical focus on sustainability matters from food, energy, etc. And what is the most crucial here is that this depends on the individual states' accommodation of sustainability agenda into national policies. There are no other ways. We just do not have any plans B, so we just should keep implementing sustainable development goals. Thank you for your attention.
Now I'm even more proud of Dmitra, so thank you, Dmitra, for a very interesting presentation. I think this presentation showed how many sensitive issues sustainability deals with. So continuing our exploration of different environmental aspects, including sustainability, now we move to effectiveness of restorative justice in ecocide crime. And I give the floor to Erfan Babakhani, sorry for the pronunciation of your family name, from Paris-Nanterre University, and please take the floor.
Good afternoon, ladies and gentlemen. I'm lucky to be present at the International PhD and Young Researcher Conference. First of all, I want to appreciate all organizers of this symposium and Vilnius University. From my background, I'm a doctoral student in criminal law and criminology at Paris-Nanterre University. And I work on the effectiveness of restorative justice in ecocide crime. For the introduction, this presentation... So, just check how can I figure it out. I don't know how can I figure it out.
No, but
that's okay. Okay, thanks. Cool.
And now F5.
Thanks. Sorry. This presentation will review some concepts elaborated upon by restorative justice and reflect on how some of them can be put with the concept of ecocide crime. Thus, it can be said this crime as a fifth most serious crime against global peace is a new threat for the human's life. The crime of ecocide, especially environmental type and government types of that, is a threat for the human's life, and this crime it destroys environment, and in addition to the threat it poses to environmental security, ecocide undermines the foundation of economic and social security as well. As the offender of ecocide crime, environmental protection laws are often violated by legal person, and more particularly corporation. The main purpose of this, the imposition of sanction against legal person, should be restoration of the damage caused. This research of restoration of damage, which is provided in Article 8 of the Convention of the Council of Europe of 1998 on the protection of the environment through criminal law, is one of the goals pursued by restorative justice. That's why in recent years, the science of criminology and criminal law have paid a specific attention towards environmental damages, damages which may put an end to the civilization of human beings. So harmonization of the response concerning environmental matters involves underlining the significance of the restoration of the interests adversely affected by the conduct of the offender. Well, in the first part, I will discuss about definition of the ecocide crime. The crime of ecocide was as a result of use of Agent Orange by United States Army in Vietnam, and term emerged in early 1970. The use of such a powerful defoliant destroys nearly 20% of the Vietnamese forest. This has had a disastrous health consequences for the population, such as cancer and serious birth defects, which are still present today. In 1990, this country established a definition of the crime of ecocide and in its criminal code, according to which ecocide constitute a crime against humanity when it results in a destruction of the natural environment, both in times of peace and in times of war. By the way, it seems that the first disciplined definition of the crime of ecocide was made by Richard Falk, and ecocide's treaty draft was prepared by his innovation. According to the Article 2 of Draft Convention against Ecocide has been defined. In the present convention, ecocide means any of the following acts committed with intent to disrupt or destroy in whole or in part a human ecosystem. A, the use of weapons of mass destruction, whether nuclear, bacteriological, chemical, or others. B, the use of chemical herbicide to defoliate and deforest national forests for military purposes. C, the use of bombs and artillery in such a quantity, density, or size to impair the quality of soil or enhance the prospect of disease, dangerous of human beings, animals, or corpse. B, the use of bulldozing equipment to destroy large tracts of forest or croplands for military purposes. E, the use of techniques designed to increase or decrease rainfall or otherwise modify weather as a weapon of war. And finally, F, the forcible removal of human beings or animals from their habitual places of habitation to expedite the pursuit of military or industrial objective. Well, undoubtedly, the most tangible negative outcome of ecocide on society and their sustainable development is its environmental outcome, since ecocide firstly is a crime against environment and nature and destroy ecosystems. Therefore, ecocide threatens environmental safety or safety of global ecology. According to what was mentioned, massive environmental damage such as climate change, global warming, contaminating of water, puring of soil, pollution, decreasing the biodiversity of flora and fauna, and also inappropriate waste disposal, especially dangerous and poisonous waste, are the outcome of ecocide. Or in another interpretation, are the result of oppressive exploitation of planet Earth. Therefore, according to the commonplace definition of ecocide, which must of it include severe, massive, and long-term damage to environments, we can estimate if the ecocide occurred, how much of environments and ecosystems would destruct. Imagine the destruction of the forests of Vietnam due to the rampant of orange agent by United States. A prominent example of ecocide is forest ecocide, or deforestation, which mostly occurred in tropical and region and rainforest. Unpleasant phenomenon of deforestation threatens human health and leads to destruction of environment, gradual destruction of natural resources, and an animal and planet extinction. An ecocide can be divided in 5 different categories: air pollution, water pollution, deforestation and the spoiling of the land, and crime against non-human species. And the second part is about towards the restorative justice and reparation of the victim of ecocide. Since the second half of 20th century, the issue of environment has found a universal dimension and has turned to be a permanent menace, a menace in which seriously threatens whatever lives on planet. Nowadays, with the growth of the global warming issue and climate change, this menace has found a new dimension. This menace is going to make a massive social changes in human lives by force, a menace which puts natural and vital resources in danger. However, the spatial nature of these crimes, which have a high benefits and low risk, has made it impossible to recourse to criminal law to significantly reduce the rate of this crime. Indeed, criminal justice alone is not able to respond effectively to such a crime. In fact, the restorative justice approach can have advantages over environmental crime. According to the Economic and Social Council of the United Nations, restorative justice means any process in which the victim and the offender were appropriated in any other individual or community members affected by crimes participate all together actively in a resolution of the matter arising from the crime, generally with the help of a facilitator, so that criminal sanctions become restorative sanctions to repair the damage of environment, and it would also be appropriate to protect the environment, public health, and more broadly the planet, to grant civil society to the right to issue a warning coupled with the resolution resulting protection. According to the Martin right, restorative justice seeks to balance the concern of the victim, which is environment, and the community with the need to integrate the offender into the society. It seeks to assist the recovery of the victim and enable parties with the stake in the justice process to participate fruitfully in it. A process whereby all parties with a stake in a particular offense come together to resolve collectively how to deal with the aftermath of the offense and in application for the future. So application of restorative justice to cover environmental crime, that criminal sanctions become corrective sanctions to repair the interest affected in the past and protect the interest concerned for the future. Restorative justice is only possible with the consent of the offender of the crime, and this implies that the offender or company that caused a damage to the environment voluntarily accept to pay compensation for that damage. For example, a novel of restorative justice conferencing occurred in 2011 during a mock trial for the fictitious crime of ecocide. A restorative justice conference was held following the conviction in a mock ecocide trial held in Supreme Court of England and Wales. The trial was conducted based on evidence of true events and publicly available documents before the real judge. An independent jury decided to convict two offenders of ecocide, and a few months after conviction, a restorative justice conference was held in which one of the offenders participated and the other one not participate. Participating in this restorative justice conference was also an oil company of this chief sustainability officer, spokespersons for the birds damaged by the ecocide, spokesperson for the future generation, spokesperson for the wider humanity, spokesperson for the earth, and representative of indigenous people living in the area affected. Innovative solutions were proposed during the restorative justice conference, including restoring the tar sand area at the company's cost, founding a university chair to research the law of ecocide, and setting up a working group to investigate founding alternative energy sources such as solar. The innovative solutions were only made possible through the dialogue restorative justice conferencing, and the sentencing judge took a restorative justice conference into the account as a mitigating factor and handed down a suspended sentences which would allow the fulfillment of the commitment made during the conference. As the conclusion, according to the Rome Statute, there are 4 core international crimes: genocide, crime against humanity, war crimes, and the crime of aggression. However, there is another widespread crime which deserves the same amount of attention: the crime of ecocide. The offender must be held accountable under the international law, and ecocide should be adopted as an international crime. Among all, ecocide, as the most important and most severe kind of environmental damage, will receive a great attention. Indeed, criminal justice alone is not able to respond effectively to such a crime. The present study tries through a descriptive analytical approach to show that restorative justice applied to ecocide crime is a justice to provide environmental revitalization and environmental reparation. The result of restorative programs repairing by population or visit at the site was affected by the damage. The founding of measures aimed at repairing local damages with the participation of all those parties having been affected by the crime. Restorative justice applied to ecocide crime is a justice that provides reparation, which requires taking into account all the adverse effects the conduct in question has held on the community concerned. Article 6 of the Ecocide Convention mentioned that the state party should adopt such a measure as may be necessary to impose effective, proportionate, and dissuasive sanctions under national and legal persons convicted for the crime of ecocide, and ensure restoration of the damage to the environment and compensation for the victims. Thank you for your attention.
Thank you. Thank you very much for a very interesting presentation. I've already have several questions for you, so if we have time. Okay, now the next presentation, also with a challenging title, The Intertemporal Guarantee of Freedom, a concept of international human rights to address states' failure to combat climate change and its threats. And it's also very, very high modern topic because everybody speaks about these cases. So I'm very glad to give the floor to Matthias Gegenwart from Frankfurt am Main Goethe University.
Thank you very much. So yeah, as it was mentioned before, I'm going to give a presentation that seeks to analyze the intertemporal guarantee of freedom that was developed by the German Constitutional Court in its landmark decision in March 2021, and if it can be used to expand human rights protection in other jurisdictions and international fora. In order to do so, we will first look at the case that was presented to the German court and its decision, and then we'll apply it to other jurisdictions by the example of Switzerland, and then we'll look at international law and the European Court of Human Rights and also the Inter-American Court of Human Rights. The case that was presented to the court involved several young complainants, mostly from Germany, but also some from Nepal and Bangladesh, and they claimed a violation of the state's duty to protect because of the unambitious greenhouse gas reduction goals that Germany had at the time, and they claimed that they were insufficient to correlate with the 1.5 degrees goal set forth in the Paris Agreement. The claims were mostly based on the duty to protect the rights to life, health, property, and human dignity, and additionally, a right to an ecological minimum standard of living was claimed. The complaints were mostly admissible and partially successful, even though the court found another reasoning than the complainants suggested. First, let's look at the state's duty to protect. In line with its established case law, the German Constitutional Court limited its review regarding the duty to protect to safeguard the legislator's margin of appreciation by only finding a violation if no measures at all were taken by the state or if the taken measures were completely inadequate for achieving their goal. Considering that an effort was taken by the German court in the shape of the Federal Climate Change Act that contained some greenhouse gas emission aims, it was deemed not manifestly unsuitable, so the court couldn't find a violation of the protection duty by the state. Nevertheless, the court acknowledged the state's duty to protect against the risks posed by climate change, while refusing the excuse of states that one state by itself would be incapable of stopping climate change on its own, and therefore no state would have an obligation and could be singled out by plaintiffs in court cases. Instead of focusing on the duty to protect, the court expanded the negative dimension of human rights. The judgment found that fundamental rights were presently violated because the allowed emissions gave rise to substantial burdens to reduce emissions in later periods, which would then lead to disproportional interferences with future freedoms of the complainants. The decision to allow a certain amount of CO2 gas to be emitted until 2030 by the state has an advanced interference-like effect on the freedoms of the complainants, as it inevitably reduces the remaining national budget of GHG emissions. The current restrictions of GHG emissions concern all forms of human freedoms due to the fact that presently all human behavior involves the emission of greenhouse gases and is thus threatened by the restrictions in the future. This then allowed the judges to expand the negative dimension of human rights and not be restricted to the widely accepted limits of the duty to protect human rights. The court ruled that the constitutional rights demand the legislator to spread the opportunities associated with freedoms proportionately across the generations and prohibits to offload the greenhouse gas reduction unilaterally onto the future and future generations. The judges used this to follow that with the progress of time, the remaining GHG budget will decrease, and due to the threats of climate change, more extensive restrictions of freedoms will become constitutional. So after we've established this case, let's look at its application in Switzerland. In Switzerland, they had a first climate change case by the Swiss Senior Women for Climate Protection. They argued that due to the rising temperatures caused by climate change and longer periods of hot weather in summer and temperature spikes would be expected in the coming years. According to studies, women over the age of 75 would be exposed to a higher risk of mortality during hot summers and would be more seriously affected in their health than the general population. The complainants argued that this would trigger the state's duty to protect the fundamental rights to life and to respect for private and family life under Article 8 and Article 2 of the European Convention of Human Rights. The court denied this claim. Denied this claim to the fact that the temperatures would not exceed the 2-degree goal of the Paris Agreement in their argument in the near future, and assumed that temperature rises could still be halted before they reach the 2-degree goal. After the dismissal of their complaint, the complainants then went to the European Court of Human Rights, and their case is currently awaiting judgment there, which should be incoming in the next weeks. The question that shall be raised right here is if the complainants could have argued with the intertemporal guarantee of freedom to improve their standing in front of the Swiss court. The basis for the court's argument in the German case was that the German basic law, the German constitution, contained the protection of the natural foundations of life as a constitutional principle in Article 20a of the German constitution. A similar provision can also be found in the Swiss law in the form of Article 73 of the Swiss constitution. It's a principle that demands a balanced relation between nature and humanity's use of nature. The major advantage of the extension of the negative dimension of human rights opposed to the duty to protect would be that complainants don't need to prove a concrete threat to their own life, as it was denied by the Swiss court. Instead, the complaining party only needs to argue that the balance of current and future freedoms is disproportionate. This could counter the argument made by the court in the case of the Swiss senior women that climate change and at the same time global warming could still be slowed down through suitable measures and prevent a threat to the life of the appellants. Even if it's still possible to keep global warming within the 2-degree goal, which can be questionable, it will not be possible without considerable reduction efforts in nearly all areas of life that will impact the future use of freedom by the citizens. The main obstacle in terms of the Swiss Federal Supreme Court lies within Article 190 of the Swiss Constitution that limits the constitutional review of the court by declaring federal laws binding for the court. But the court has in recent times expanded its judicial review towards acts of the legislator to enable the principle of subsidiarity within the system of the European Convention of Human Rights. Based on this expansion of its review, the court could judge on future climate change litigation by invoking the intertemporal guarantee of freedom, even if the chances of success seem to be limited regarding the scientifically broad claim by the Swiss senior women in front of the court. After this example of another jurisdiction, let's look at international law and especially the Human Court of Human Rights and the Inter-American Court of Human Rights. Within the European human rights system, there is not a guarantee to a healthy environment. Notwithstanding this lack of a guarantee, the European Court has expanded existing rights like the right to life and the right to family and privacy out of Article 2 and Article 8 of the European Convention into a protection against climate change. Currently, there are multiple cases pending in front of the court, most notably one against the inadequate action on climate change by 33 member states to the European Convention on Human Rights, as well as the aforementioned case by the Swiss senior women, and another case of Greenpeace Nordic v. Norway, where the applicants also claim mainly the violation of the rights to life and privacy and family life. One common problem for climate litigation in front of the European Court is that according to Article 34 of the European Convention of Human Rights, a present violation of human rights has to exist. With cases where the applicants allege insufficient protection against the harm of climate change by the state, there often only exists a danger towards a future violation of their rights due to climate change that will most likely not be preventable anymore as soon as it is imminent enough to be claimed in front of the court. So, and additionally, the court, similar to other human rights bodies and constitutional courts, also gives the legislator a really wide margin of appreciation concerning its positive obligations due to the separation of powers and the counter-majoritarian difficulty. These difficulties could be addressed by the intertemporal guarantee of freedom. As I mentioned before, the German Constitutional Court constructed this guarantee within the negative dimension of human rights. This meant that the court did not grant a similar margin of appreciation as it does concerning positive obligations of the state. Moreover, the court did not focus on the state's duty to prevent GHG emissions, but rather highlighted the future use of the freedoms that are connected with GHG emissions, hereby forcing the legislator to distribute possibilities of freedom within time between the current use of freedom and the future use of freedom. This can lower the burden of proof for applicants, since they do not have to prove that they will be threatened personally by the dangers of climate change in their health or even their life. If the European Court of Human Rights argued in a similar manner as the German Constitutional Court has done, it could focus on the multitude of rights protected by the Convention and its existing case law to demand its member states to carry out a similar distribution of freedom by enforcing climate change action in present times. Following this guarantee that was established by the German courts, the applicants would only have to prove dangers to the exercise of their fundamental rights protected under the European Convention, like the right to respect for family and private life, the freedom of expression, the right to property, the right to work, the right to the freedom of movement, and all these rights insofar as they involve GHG emissions. Due to the work of climate change science and the commitment of most states in the Paris Agreement, it is significantly easier to argue that all these rights will be endangered than it is presently handled by the court in cases where a threat to life and health is being put forward. This could increase the chances of climate change litigation before the European Court, not only for cases like the Swiss senior woman, but especially for younger applicants, as it is in the case of Duarte Augustinho and Greenpeace Nordic. For an adoption of this guarantee by the European Court, the question remains if the court is willing to reduce the leeway of states for their legislation on climate change. Such a recognition of the distribution between current and future freedoms would not constitute a disruption of the court's rulings. The European Court of Human Rights always has regarded the Convention in a dynamic and involving manner and keeping up with current challenges as it has done before with climate-related issues. Yet it cannot be disregarded that the European Court of Human Rights typically affords a much broader margin of appreciation than, for example, the German Federal Constitutional Court or other constitutional courts typically do. Let's look at the Inter-American Court of Human Rights next. Within the Inter-American human rights system, there already exists a right to a healthy environment, which is stated in Article 11 of the San Salvador Protocol. And in an advisory opinion, the Inter-American Court of Human Rights has already recognized the importance of this right for human rights protection and constituted states' obligations to prevent transboundary damage wherever the state has effective control. Furthermore, the court obliges the states to regulate, supervise, and monitor activities with environmental impacts and binds the states to the precautionary principle found in environmental law. Due to this, there is currently no advantage by an application of the intertemporal guarantee of freedom within the inter-American system, as it already protects the human rights involved with climate change far more than the other courts have done. Still, the rulings in following cases will have to be critically accompanied to ensure a broad protection against insufficient climate change action by the states that are part of the inter-American system. In conclusion, we can say that the example of the case of the Swiss senior woman for climate protection shows that there is a case to be made to expand the intertemporal guarantee of freedom to other jurisdictions. In the paper, you will also see a similar argumentation for Norway. Within the international dimension and international law bodies, it really differs because the inter-American system already provides broad protection against climate change issues, whereas the European Court of Human Rights hasn't done so. Still, the courts and the committees have used different guarantees like the right to life and health, as well as guarantees towards privacy and family life to substantiate their interpretation. A major deficit within the international human rights protection against climate change lies within the focus on the positive obligation of the states and the corresponding wide margin of appreciation granted to the states. The intertemporal guarantee of freedom could provide a protection expansion in this regard, especially in the cases in front of the European Court of Human Rights. It could also enable and legitimize present human rights concerns focused on the future actions of states following their past inaction. The intertemporal guarantee of freedom cannot solve major problems for climate change like procedural hurdles, as it is in front of the European Court of Justice, and issues like the judicialization of political questions, as well as the countermajority in difficulty. Still, it can provide a new approach for complaints to address unambitious mitigation legislation by states, which will then lead to future rights infringements. Thank you very much.
Also very interesting presentation, and again many questions, but now we have to we have another presenter with another very interesting presentation on climate change as a challenge and opportunity for relationship between criminal law and morality. Tjarda Tedeken, if I pronounce your name correctly, from Frankfurt Main Goethe University. Please take the floor.
Thank you very much, and I'm just trying to start. Thank you. Yes, I'm smarter than everybody else. Start the slideshow. There we go. Yeah, I know, lawyers and IT, right? Isn't that a thing? So, my name is Tjarda Tedeken. I'm a research assistant at the Goethe University in Frankfurt am Main, and I am doing my dissertation project on in criminal law on environmental activism, and that is where the question arose that I'm coming here with today, which is how climate change might be seen as a challenge, but as well as an opportunity for the relationship between, in particular, criminal law, but law and morality in general. Well, let's start off with a rather basic question. How are law and morality related? So we all know that moral values are not generally legally binding because we do have a pluralist constitution in, well, most European countries by now. So they do, however, influence and might even be part of legal norms. For example, the German Federal Constitutional Court has not rejected the possibility of the protection of moral values through criminal law. It has even stressed that the German Constitution is not neutral in its values. So that means that we do have a very high impact of moral values on the law. So what does this mean for the relationship between law and morality in relation, to environmental activism? Well, environmental activists may come into conflict with the law and potentially even criminal law. In this context, the term of civil disobedience is often used. Why? What does civil disobedience even mean? I am going to provide you with a definition in this presentation that is based on the German dispute on the term, even though the term originated in America. So there are 4 main criteria that must be met in order for an action to be considered civil disobedience after this definition. Firstly, the actions must take place publicly, so not in the hidden, not in the secrecy, but they must be out in public. Secondly, we need an action that is to be considered of symbolic value, so it must carry a certain message. Thirdly, we have to meet the criterion that this action is non-violent. Non-violent meaning that there is an absence of direct physical force against either persons or objects. And, that's the 4th criterion, the actions must be potentially punishable by law. I'm not saying that they definitely are, but it must be within the range of the considerable that they are potentially. So, after we now all know what civil disobedience is, we must see that it is often considered morally justified. So an action that is considered civil disobedience is often seen as morally justified, but it is very highly disputed whether it should be legally justified. Is a justification for a morally justified action also necessary in law? Well, my proposition that is a little bit provocative potentially is that, yes, we do need a justification, at least partially, so maybe a little less provocative. And why is that? Why do we need a justification for civil disobedience, at least in parts? Well, first of all, if actions are morally justified, it actually goes against a sense of justice to punish them. So civil disobedience might just be exempted from punishment because for reasons of justice. Well, law and justice are not the same. We all have been mistaken in our sense of justice, and our perception of justice may differ a lot. So clearly, this is not the only reason. Based on that, we need a justification. But, oh, I already skipped that. Still talking about that. We do have a superiority of civil disobedience over, I call it, common crime, which results from a contrast between the first criterion, which was the publicity of civil disobedience, and common crime, which is actually committed in secrecy. Further, the actions of civil disobedience actually lack the selfish motivation that underlies common crime. The activists do not claim an exemption from the law for themselves, but in order to achieve political change, I already mentioned there is a symbolic nature to civil disobedience as well. And the activists have long-term goals. Civil disobedience is there to protect the rights of the people of the state, and in relation to environmental activism, even the rights of the international community. But is this enough to justify such actions? Because after all, activists still breach the law, right? So the most important argument for justification on a legal basis of civil disobedience is the so-called relative effect of majority decisions. In a representative democracy, the minority must actually subordinate itself to the decisions of the current majority, at least for the duration of the election period. However, if decisions have irreversible consequences, there is no possibility for a minority, should it ever become the majority, to shape the future according to its ideas. Securing the possibility of current and future generations to exercise their constitutional rights is thus the task of the democratic state. I mean, Matthias has already talked to us about the intertemporal guarantee of freedom. And it is thus actually against the principles of democracy if a state makes decisions with irreversible consequences that seriously and permanently threaten constitutional rights of not only the minority, but of everyone. So, consequently, actions aim to prevent state decisions with irreversible consequences. Actions aim to preserve constitutional rights. Actions aim to restore the balance of power within the system. Actions that preserve democracy cannot be accompanied by punishment. This means we are in need for justification. So from the reasoning I presented, I have derived a criterion, the so-called irreversibility criterion, very easy to pronounce. Substantially, this criterion serves to actually limit the waiving of punishment to actions of civil disobedience taken to preserve fundamental rights. So such actions shall only be justified if otherwise consequences of state decisions would create an intolerable and irreversible situation regarding those rights. But there are a few problems with this criterion, and I will demonstrate this to you by using an example. That's a little longer. Well, we imagine we have a group of people who occupy a forest after their protests and signature lists did not actually result in a prohibition of the construction of an e-car factory by the authorities, even though, obviously, this project will actually increase CO2 emissions and it will likely cause a drinking water shortage in the region. This is actually not even fictional. This is actually a real case. It's a little bit amended. But what if, and we stick to this a little bit amended case, what if those people were to protest peacefully but unlawfully in order to prevent the construction of this e-car factory to protect the climate? Could their actions be justified under the criteria that I've mentioned? Well, first of all, we need this action to be considered an action of civil disobedience. So we need it to be public. Well, Very clearly, these people are occupying a forest. This is not crime and secrecy. They are there, they are out in the open, so we do have a public act. Secondly, it needs to be symbolic. Well, very clearly, those people are trying to protect the environment. They're occupying the forest. They've tried signature lists, so there is also the symbolic meaning of environmental protection to it. Thirdly, they must act non-violently. Well, we do read that they protest peacefully, so we just assume that this is not violence. And then lastly, it must be relevant from a legal perspective. And, well, occupying a forest unlawfully blocking a site means that you can consider those actions under criminal law. I don't know, so blocking of sites in Germany at least has been discussed very broadly, especially as an action of civil disobedience, and can thus actually be considered a criminal offense. So that means we do actually meet all the criteria of an action for it to be civil disobedient. That means we do have an action of civil disobedience and can now look into whether it is justifiable under the irreversibility criterion. Well, we would have to have a state decision with irreversible consequences here. But there are a few parameters that we need to consider. Well, first of all, we have the factory construction. The factory construction can actually be reversed quite easily. There can be a stop of the project, there might be a stop of the operation, or the factory itself might be built back. So this is still irreversible. However, we also have deforestation of the area. The forest can very obviously not be easily restored after it has been cut down. So we have a biotope that is lost. We also have an area that even if it is reforested, the capacity to absorb CO2 will only be comparable to before, after decades of growth of this new forest. Then also we have emissions. Once the emissions to build the factory have been emitted, the emissions to run the factory have been emitted, they cannot be taken back. And then also we have water usage. We cannot simply transfer the water back into the ground. So the water that has been consumed is already used. And then also the groundwater level may no longer be stable or stabilizable. So those are actually consequences of this factory construction for the region and the warming of the climate that cannot be reversed. Does this mean those actions are justified? Well, as I said, there are a few problems to this criterion, which is why I'm coming to this now. Well, what are those problems? Firstly, the criterion gives no guidance on whether or how to account for possible long-term effects, positive long-term effects of state decisions. For example, CO2 compensation by the use of electric cars built in this particular factory. So how can this be taken into consideration? The criterion gives us no answer to this. Secondly, it cannot be derived from the criterion how positive consequences for the climate and negative consequences for a single region, for example, overloading of the water reserves, can be weighted against each other. May potential effects could be considered, or only certain effects, can only those be accounted for? And thirdly, it actually remains unclear which state decision can be taken action against. Any decision leading to the emission of CO2 must be considered irreversible. So is there a threshold for the impact a decision must have? The criterion does not provide us with an answer to that either. So as a conclusion, we do need a justification due to, one, the superiority of civil disobedience over common crime and the relative effect of majority decisions. If we have an action that is to be considered, one, civil disobedient, and secondly, to prevent state decisions with irreversible consequences. However, as said, this criterion poses a few problems, which is the lack of differentiation of the irreversibility criterion. God. So, what can we derive from this? Well, there is actually a lack of practicability. So does this mean we should just not implement a justification? Should we just stick with the general rules? What are the alternatives? Should we just, well, apply maybe a penalty reduction at its best? Well, as said, there might be a lack of practicability. So from a perspective of a practitioner, the answer might just be yes. However, from a theoretical perspective, the answer must be no. Thus, it takes legal scholars like us to find a solution to this conflict between law and morality, the outcome of which may be uncertain. However, it actually remains clear that anyone who stands up against climate change for the preservation of democracy and even of humanity itself cannot be treated like a person who transgresses the law out of pure self-interest. Thank you very much.
Thank you once again. And now, last but not least, Margot Papy, doctor from Panthéon-Assas University Paris 2. The topic is challenges and impacts of incentives policies in energy, international constraints, European policies, and national adaptation. Please take the floor.
Hello, everybody. Unlike everybody else before me, I do not have a presentation. I've never been really good at talking with presentation behind me. I prefer to face you, and my speaking abilities might be actually a bit clearer. So first of all, I would like to thank the organizers for giving me the opportunity to speak to you today and to share the work that I did. As it was presented, I am a doctor in law for 2 months now. I finished my research project in April. Thank you very much. I've spent 6 years working on the subject of incentive policies in energy law, and I have a background both in economic and law degree. Although I'm here today to present you a bit of the originality of the context of my work, the specificity of my topic, and also to present, because I finished it, the conclusion of my work. So as the program stated, my topic was on challenges and impact of incentive policies in energy. What is incentive policy? It is a very interesting, let's say, notion under law, because it is not a traditional rule of law principle. It is something that allows the legal framework for more flexibility than what we know as a jurist as the rule of law. So it is systematically often systematically uses as a mechanism to implement measures that are actually more flexible, which is needed in the energy field, mostly because of technical aspects, because of social aspects that are under energy definitions, financial needs, but also political context. So I have 3 things that I want to go through with you today. First, why was my work original in its context? I worked while doing my research because we have this option to do a PhD in France, which is called CIFRE. We can actually be employed by either an institution, a company, an NGO, and actually apply our research to a practitioner point of view. So I gathered business experience. I applied my research to what I was doing on a daily basis. I could also criticize from both perspectives, which gave me also kind of a bipolar mind at the end of my 6 years, you can imagine. Why this bipolar aspect? Because in the work environment, you're required to work fast, to be operational, to be solution-solving driven, client-oriented, and everything you do must be short, right? And then you have the research aspect, which is, let's say, slow. I studied for 6 years. It is It takes a lot of time to get started, and it takes a lot of time and needs to be slow in the process. It must be detailed. It must be a complete analysis, academic-oriented, obviously, and it's a very long work. So that was the originality of my context of work. The specificity of my topic was that incentive policies in the energy field are actually not only requiring a law-oriented analysis. It requires to look at economical aspects. It requires to look at environmental aspects on a very scientific approach and ecological approach. It is an urgent matter. Like my topic right now in France is on all the conferences topics. It is probably the most spoken topic right now. So I had this urgency to come up with solutions to propose. There was this problem of accessing data, because the data, I don't know if it's the same for other students, but for me, in energy, it's a very tricky thing to say and come up to institutions with. I need actually, you know, very contemporary data on how much energy, when, how, why. All of this is very complicated to have, or it's biased, because obviously it comes from an institution that has kind of that oriented the data and for its own purpose. Also in France, the legal framework of energy aspects is very recent. Before it was actually spread within different regulation, and it was actually into environmental laws, into construction laws, into energy laws within the sector itself, but now it has its own legal base, and that was very recently built, so it was also another challenge. At the EU level, because my focus was to have a look at those policies from an international, European, and then the adaptation under the French mechanism, the EU law on policies on energy is actually always changing. Like, as an example, I did my defense in April, but like a few weeks before, new communications came out, and I had to actually change huge parts of my PhD to reorient everything and actually be with my time, right, working with my time. So it was really, really hard to come up with a full analysis. At the international level, it was said in the previous presentations, it is very abstract, it is non-binding. Those commitments are very hard to find detailed analysis on how people are actually implementing those policies in order to reduce energy demand. So that was why I focused on the target of the policies rather than where it's coming from. So I chose to look at what are those policies doing to the end using energy actor, so to the consumer. So of course those difficulties were also opportunities, so I really used it for the best of it. So I would like to present the few things I came up with after my work was done. So those are conclusions and perspectives. I started with the hypothesis that how do we define those incentive policies in energy? And what are the impact of those policies on the chosen incentive measures to reduce the energy demand? So I saw, and I lived because of my work I was doing every day, that it has an impact on the nature of the measure we choose. It has an impact on the interactions from those measures with other legal tools, and it has obviously limits, as we can see with many different mechanisms. So the goal of my research was to give transversal analysis with those different fields that I talked about earlier, economic, social, politic, but also from an ecological point of view, to insert, which was original, the practitioner vision, because obviously it's not always the case. It's really hard to do research plus seeing how the practitioner are actually living those issues, the legal issues we're studying in the academic field. But also I wanted to come up with ideas and solutions, because I wasn't studying something in the past, I was actually studying something in the future. and with a very humble process, I wanted still to add a piece to what was coming. So what I came up with after studying what are the incentive policies in France to reduce the energy demand was incentive instruments should be based actually on the accountability of the broad range of stakeholders in the energy field. So the consumers obviously are a big part of that. And how can we do that? How can we guarantee this accountability? Well, I actually think that it should be done by sharing knowledge first. I think that what we're doing today is actually very important, because if we don't share the knowledge we're on a daily basis working on, it will not be very useful for anybody. So we should keep talking about it and keep making sure that it's understood by the people we're talking to. Obviously, it should be included in education programs from very little kids to diplomats and government and policymakers. It is a big topic right now in France. People are saying after the presidential election, okay, now you have a new government. What do they know about the topic? And actually, people are saying maybe they should be trained by specialists. Maybe they should actually talk to researchers, to professors, and understand a bit better what's happening in the energy, on the energy matters, and broadly on the environmental issues. We should also train workforces to be actually able to implement those measures that we are choosing, because there is a big lack, for instance, in France of workers that are implementing solar panel, electrification, and other. We cannot have people working on those projects anymore. We are actually hiring people from elsewhere all the time because we are lacking people who know how to work on those topics. But also, and I found it was my key aspect in my research, we should create and guarantee. So it's actually good that you presented right before me, because I came up with this eco-citizenship, which should guarantee the right of people to express what they think about all those decisions, all those projects. There should have been a decision with those people, so that should be through public debate. That should be enhancing the legitimacy of all the projects that we pick right now to develop. And the legitimacy is actually a big issue right now. I think most of the topics that we are talking about in the energy field must be based on a legitimacy model. So how can we do that? Well, basically we have tools that are innovation. We are, in a way, participating in innovation. Financing, obviously, if we don't have the finances to implement that, it will not work. But also the synergy of the stakeholders. It was mentioned before that to have a restorative justice, you should have people agreeing to talk to each other and to repair rather than being under criminal sentences. Well, I think this synergy should be the basis of the democracy. And obviously a political consensus as well. Like we've seen it. Of course, international treaties are not binding, but they are a way to create a political consensus on urgent matters.
I'm sorry to interrupt.
Yeah.
1 more minute.
Yeah, it's my conclusion. It's perfect. So my conclusion for today, 6 years ago, I picked a topic which was on energy sobriety, which was not at all considered as a solution. It was more considered as a collateral of implementing other solutions. Today, it is considered as the main tool for a better, resilient society. And indeed, the cheapest, the greenest, the fairest, I wanted to say the safest as well. Energy is the one we just don't use. So maybe that's the key we could all, conclude on. Thank you very much.
Well, now we still have 11 minutes for discussion, and we have Facebook question to Matthias. Though I think it's from the audience, but just posted up on the Facebook. So the question example, there is an Article 47 of the Charter. So what is your opinion?
Yeah, if I can quickly speak to that. The problem within the European system is that the European Court of Justice really doesn't define the admissibility hurdles broadly, but is limiting it to the Plowman criteria, and with that it's really hard to implement the intertemporal guarantee of freedom. It's it's actually something that I will address in the written paper for the European Court of Justice, that there's not much leeway to implement the intertemporal guarantee of freedom. This doesn't mean that not other environmental arguments can be argued, especially Article 47 of the Charter is a way to argue. Ironically, you probably have to say that climate change will have to increase for human rights arguments to be accepted in front, especially of the European Court of Justice.
Thank you very much. I saw some more questions in the audience. Do you?
Awesome work. Thank you so much. I've started drafting up my questions when Dima started speaking. May I refer to you as Dima because I can't pronounce your full name? Thanks. So you referred a few times to the United Nations, and I remember I was reading their data a few weeks ago, and they said that the only and best strategy is to invest into the developing countries because the issue is not regarding the Western countries. It's about India and so on. And they said that this should be the key role, and I think that we have showed solidarity regarding Ukraine. Perhaps the people themselves could show some more solidarity regarding India, but I think that the first step should be, promoting, educating people and promoting them not to buy stuff that is greenwashed and from these developing countries. So, and I've noticed that there are many objectives, and I suppose that they are not of equal value, or are they of equal value? Oh, and Mrs. Rigsdiniena, you should be proud, yes. I wanted to say. I am proud. That you should be.
Yeah, the Sustainable Development Goals, they are equal, they are integrated, and you cannot follow one goal and not to think about another one. Of course, there are problems when you cannot achieve all the Sustainable Development Goals at the same time, but you still need to concentrate because they are quite interlinked.
Okay, understood. Tiara, I also will have some questions regarding EFMA.
I will only add to what Carolina has asked. So I don't know, maybe Dmitro or Matthias, I don't know, all of the panel. The issue is with focusing on developing countries is that what also United Nations made this conclusion is that, you cannot just immediately go on to high-tech companies and businesses in developing countries. And what I also read by Bjorn Lomborg, he's a Dutch environmentalist, he said that the transitional period should be basically that you build coal power plants in those countries until they reach the economical level, till they actually can make those high-tech developments. So what are your thoughts on that? Because that would be a very unpopular decision to explain to the popular society and the West that we're going to invest in those countries to build their economies with very unpopular ways that we cannot perceive them as environmentally sustainable.
Who would like to take that now? I can start, yeah. I can have a first go at the question. I think that you're really right in saying that there lies a really big discriminatory problem within CO2 emissions of different states, because industrialized or early industrialized states have had so much greenhouse gas emissions, but it's a question, can you grant the same to states that didn't have that yet? I think that to address this question, we have to, as you said, have a certain amount of time where we will not put the same pressure on those countries as we do currently do on like Western countries, but there has to be like a goal setting, and that is what is especially established by the German Federal Constitutional Court. They were like really aiming at like a goal setting. You have to like constitute a way now how you want to get to like a net zero emissions.
And then I might just add to the idea of building cold power plants, as you called it. I am not sure if that is the way to actually deal with this, because I think we do, very luckily, have well, a large movement forward in technology at the moment. So by the time that they might be able to, well, work with those power plants, they might actually not meet the standard of technology anymore. We might have actually progressed past that. So I don't know if this is the way to invest in those countries, or if there is not better ways to help. And I'm very clearly no expert on this, and I'm very clearly not an environmental technician, so I cannot answer you on how to do that. But I do doubt that the technical standard is going to be the same by the time that they could actually start using those coal power plants.
Yeah. Thank you. Are there any more?
Yeah. Thank you. Thank you all for your presentations and ideas. I have a question for Erfan, my buddy. Indeed, you developed the idea of recognizing ecocide, but is there not a problem concerning legal person, as, for example, genocide or homicide? There's the question of legal person that is recognized. For instance, a fetus that is killed by accident, because he has no legal person, it wouldn't be recognized as being, for example, a homicide. Therefore, do you think that legal person should be recognized for nature? And if so, would there not be problems regarding the definition of a legal person, meaning that it has obligations, as we do, but how nature can be debtor of any obligations? So I was just wondering, how did you consider the idea of recognizing such in link with the idea of legal persons? Thank you very much.
Thank you for your question. Actually, restorative justice can be applied for legal person, because normally ecocide can happen by some factories, some legal persons. So they polluted waters, they put waste on the rivers, or water pollution, air pollution can be happens by legal person. So these legal persons have a legal presenter as well. So this legal presenter could participate in the restorative mechanism for being responsible to restore the river or whatever affected by their crime. So we cannot justify, yeah, this legal person cannot be responsible because it's just a legal person. So adversely, yeah, the restorative justice can be applied as well for legal person. And what was your second question?
No, it was one full question.
It was just one. About victims. So representative for the victim can be some NGOs, some a spokesperson for the birds damaged or birds being victims, or some NGOs for the nature can participate for reparation of the environment. So these NGOs or the representative could participate in the conferencing or the other restorative mechanism, and they can fulfill the right of the victim in this process. So, yeah.
Thank you.
Welcome.
Sorry, need this. The generous organizers allowed me to have the next question. So, Tiara, you have an astonishing approach to the issues, but as we talked after yesterday, I think I need to provoke you a little bit, because I believe that your research neglects the fact that protection of private property as well is a fundamental human right. Nevertheless, it's enshrined in the Constitution, and I think I would argue with the scope of a non-violent exactly how you categorized your case as being non-violent, because I believe that occupying private property is indeed a violent crime, because you said they used force against the private property, and I don't see why the owner should suffer the consequences, basically, that the state granted, allowed to have that factory built in there. So how do you aim to tackle, I'll just provoke you, let's say I believe that it's more moral to protect private property, regardless of it, and it's oh, don't get angry at me.
I'm not angry, I'm just
So
German.
what would be your approach?
Well, I might just answer to that question that in my case, nobody ever said it was private property. It could have, well, just been state property. But yeah, you can occupy state property, theoretically. It was private property in that case. They had already bought the land. So yes, there is an obligation to protect private property, but we need to ask ourselves, if we do not protect the climate now, and if we do not act on this, is there any private property left that we can protect at some point? So I think it is more a question of how much do we stress this at the moment, and I'm not saying that they are not potentially punishable, and I said there are some errors to this criterion as well, and I'm very clearly not aiming to justify civil disobedience as such. So and I have left out a lot of criteria that are there to actually determine whether an action is civil disobedient or not, and whether it should be justifiable. So basically, I just kind of broke it down in this presentation as well in order to establish like a minimum consensus on what is civil disobedience. But there are also more criteria like, shouldn't it be like the last action to resort to? So can we only justify it if it's the last action to resort to? So for example, if they, as the persons who now occupy the site, if they have, for example, exhausted all judicial procedures, yet they have not reached the goal, but it is potentially clear that those consequences are going to be there. And I mean, if you live in this region and your groundwater levels are going to be depleted, and you know that there is a shortage of water that comes with climate change in hot summers, what would you do? I mean, would you just sit there and wait? So I do see that there is, well, with this urgent topic, that there is a need for a higher protection of those people who are going to be affected, because they are not going to be able to live out any of the guaranteed rights by the state. And I do see that their rights to health and that their rights to life might be challenged, and those rights are very clearly higher than the right to property, because those are your ultimate rights. There was a second question, I'm not sure.
Yes, I have a question.
Now
Okay.
we give the floor to the last question because the time limit is over, but the discussion is very interesting, so I cannot stop it. So please.
Okay, so I will try to be quick. So I'm just wondering if this, what you propose, is rather a way of introducing a certain framework, legal framework for solving certain social conflicts, similar, for example, to collective bargaining in employment law. So extracting a certain socially sensitive area and trying to civilize this conflict by granting certain rights to different parties, for example, enabling such an action, taking in fact, making what is unlawful lawful, and trying to whiten those obligations and rights of those sides, or is it in fact making the civil disobedience lawful? Because I think that traditionally, but I'm not an expert on this topic, but I think that traditionally civil disobedience is a political act, and in its essence, it contains this element of being eager and being able to carry this burden resulting from the legal sanction. So if there is a law in its basic definition, ranging from St. Thomas till Hans Kelsen, there must be a sanction. So if you take the sanction out of the law, then it is no longer the law. So I just think that is it rather building a certain framework for solving the social conflict, rather than in fact like adjusting something to the framework of social disobedience. And if you recall the history, so the first case of social disobedience, this that you mentioned from the United States, it was the case of not paying tax and being sent to prison because of that. So in its essence, the person who committed this civil disobedience took this burden of being sanctioned. So just which way, in fact, do you go?
Okay, so about your, I say, example of civil disobedience, because it is where the term originated from, which is Thoreau. But the thing is that in the German discussion, civil disobedience is seen very, very differently. And this is very important to understand here, because I, going with the German discussion, would not consider this civil disobedience under my definition, because it is the action of a single person. So civil disobedience, as understood in Germany, is a movement more than the action of a single person. So I think that is where a very important difference lies. So it is not that you just yourself decide this law does not apply to me, but it is a group of people. So there is a significant amount of, well, civilly driven force behind this idea. And then, yes, I am aiming to establish a certain justification for certain actions. However, as I said, the irreversibility criterion itself will not be the only factor that I will use to then narrow down this justification in order for it to be not too broad, not to apply to all of civil disobedience, because I do see that the definition is very broad, and I think that itself is fine, but there needs to be only a small portion of civil disobedience that can be justified after all. However, I disagree with the criterion that you need to they do say that you need to accept the sanctions even in order to be accepting of the existing political system, in order to actually still show that you do abide by the rule of law. But let's take the case of Edward Snowden. Consider this civil disobedience under the American definition. Okay, well, he actually committed the crime, he disclosed this data, and he was actually willing to take those sanctions, coming back to America and knowing that he would face a long time in prison. However, the United States of America failed to ensure him that they would not torture him, which is the reason why he never went back. And I personally must say, I cannot ask of a person to accept the sanctions of a state if they know that those states might not even, stick to human rights and treat them the correct way. So that's a very extreme case. But generally also, I do not see the conflict as much as it was portrayed before, between sanctioning and that only if you accept sanctions it's civil disobedience, because I also think that it is a more, it's a movement that kind of gains momentum. People kind of taking more and more action against environment, against climate change. So I think this is like a very specific topic. So I'm really focusing on environmental activism as civil disobedience. So this shouldn't like be applied to all civil disobedience, which is also very important to say. And I would take your question, but I think
I think we could continue for hours now to discuss, to find the balance between interests and rights and so on, but we have to finish the session. And I see the Dean here, so maybe he will join us here in front and close the conference. But first, while the Dean is coming, please give the raise of applause to the Dean.
Thank you, colleagues. Thank you, Indra, for this moderation of the session. I think that you have finished with very nice conclusions. The conclusions, I think we all share that this is only the beginning of the road. You are at the beginning of discovery of your life, because what you are doing now as a young researchers, as a PhD students, this will lead you for all the way to your destination. And I just remember the German saying that our objective is not the final point, but the way. So der Weg ist das Ziel. And I think that this is also what we all share as researchers, that we don't know the answers. So that's why we are participating in the conferences. That's why we are going and visiting the conferences and friends and creating the networks and doing something which is extraordinary to some people. But for us, this is the way of our life, that we meet, we share, we talk, we're not afraid, and we travel a lot. This is the beauty of our profession, I think, and I hope that also you fall in love with this way of life, with this liberty, liberty to not only to investigate, not only to research, but also the liberty to feel free to expose your ideas, to lead others, and also to be, like lighting the way forward. In the discussions, we are not only expressing our views, but we are also expressing our doubts, our questions, our uncertainties. And this is also the part of our life. This is also the part of the profession, and also the part of the lawyer's profession. And not to answer, but to pose the good questions. This is always one of the objectives. And my saying is to my students is, please try to pose the good question. The good question is the beginning, not only for you, but also for me to think again and again. And I like very much also Latin saying, docento decimus, by learning, by teaching, we're learning. So I think in your career, you also will understand that when we talk together, when we have a question from the audience, when we can be able to freely communicate, we are able to grow, to enrich ourselves, and to enrich all others who are in our proximity, who are also sharing the lives with us. So, and I think that you are also motivated, that you feel also a bit brighter after this seminar, after this conference, and I'm looking very much forward to see you, to follow your career. I hope you'll be having a very bright future, that you will be successful in everything what you do. And just remember what is the key, what is the formula for success. The formula for success is openness, is friendship, and ability to speak the liberty. So this is something we all share. We should keep this in mind, and don't forget that in the way of your career, or at the end when you have already your paper done, the presentation is done, You don't just remember what is important. You know, I had a very also good wish to you that when we have questions, for instance, what is a dissertation? What is a thesis? What is the paper? Actually, the answer is very simple. Those are the questions who has never asked. And the answers are not interesting for anyone. Only for you. But that makes us also critical about ourselves, but also maybe motivated to look into something which is inside of us, inside of our nature, to question everything and to be able to, by way of questioning, by way of thinking, by way of reflecting, to grow and also to share our knowledge with the population, with the people, and with the colleagues. I hope you liked the conference, staying here in Vilnius. The visit for us was extraordinary because after a very long time we were able to meet in person. This is a wonderful feeling. And I would like to wish that this kind of cooperation feeling would guide you through all your professional life, and you will be able not only participate but also to organize. And I promise to come. So, thank you. Have a nice trip back, but also I'd like to also ask Eric and Monica to say very few sentences. Maybe you could also wish something to our colleagues.
But as ever, there is nothing to add. You said everything. So it was a great conference. It was good to have this conference again. I can't remember, but it's 5 years, 6 years ago that it started. And well, it's just a first step, and there will be many more. And I hope you will be again with us as a doctoral student, and then again with us as organizer, professors, dean, rectors, and so on.
I can add something. I would like to invite you all for the next event of our network to Łódź, to Poland, and we will organize in March, probably March or April, the next seminar for the students of the universities of our network. So I am really very happy. I'm looking forward to seeing you in Łódź.
Dear friends, colleagues, thank you very much. All the best. Have a nice trip back. Have also a few hours here. He left in Vilnius. I know that the Friday evening in Vilnius is a magic time. Yes, and thanks goes to Jurgis, Justinas, Kęstutis. You made a wonderful job. Thank you. Thank you very much. Thank you. Till next time. Thank you.